Ms. Barnes, are you able to hear things in the courtroom now? I'll take that as a yes. And Mr. Powers is maybe the iPhone 13.
I believe that's him, Judge. Yes.
Great.
Yes, that's me.
Great. All right. So he can hear us. So Ms. Barnes, I don't know what your issue is, unfortunately, but Mr. Powers can hear us, which means the signal is pulsing out there. All right. Let's talk not on the record for a minute because we aren't able to get a record going quite yet. We are here this morning to talk about a motion for contempt that Plaintiff, Williams Industrial Services Group, has filed. Some concerns were raised in the motion that Mr. Powers has continued to work for Champion in ways that he was instructed not to, taken steps that are inconsistent with either the terms of the non-compete or instructions I provided that I meant to be clear. And then there's even this wild card of taking the Braves tickets from Williams, which will be interesting to hear about. And there's much more detail to all that. A lot of this came to light after Williams was able to get some discovery that involved electronic communications between Mr. Powers and colleagues at Champion or people who maybe used to work at Williams and contact with, I believe, competitors, not competitors, potential clients of both Williams and Champion. But I'm going to let the parties flesh it all out. Was there anything else, Mr. Schneider, that you were hoping we'd cover today, or we are all about contempt?
I think that's a fair summary, Your Honor. And
are we doing all right with discovery?
we have a pending motion for spoliation. I think their response is due. Mr. Powers' response is due in a few days. Other than that, there's been some 6.4 letters back and forth.
But they're at that level right now.
They're at that level. Nothing's
Okay.
been filed at this point.
Hopefully we can keep them at that level. All right. Mr. Kapler, good morning.
Morning, Judge. Good to see you.
Good to see you. Anything brewing on Mr. Powers' side other than responding to spoliation, contempt, et cetera?
Initially, there's a couple of things. You know, we're on appeal of the court's order on the injunction.
Yep. And
there was a case that came down about a week after your order came down that I think is dispositive, frankly, on the issues. And so we briefed that. We filed our brief a couple of days ago in the Court of Appeals. I think it was on Wednesday of last week. So that's up there. You know, they're doing their thing. There are we do have a response to their spoliation motion. I think it's due on Wednesday. And we're going to respond to that in due course. We're still going through some of their discovery responses, as Mr. Schneider indicated, but nothing's ready for the court's involvement as it stands right now.
All right. This case that just came down, is it from the Court of Appeals or the Supreme Court?
The Court of Appeals, Judge. It's called a Burbach or Burbank versus Conyers Motorsports.
And it undoes the wisdom of, what was it called? Cut, shave, cut?
I think it does. It does a couple things. You know, shave, that was your case too.
It was. I didn't realize that when everyone was saying, oh, there's this amazing case. And then I looked at it, I'm like, it was really amazing. I mean, that's one that's like should be up on everyone's wall.
You know, I had it on the wall trying to find out the reasons why it was wrong. And I think one of the biggest factors and what Burbach talks about is, you know, this overbreadth of working for any competitor in any capacity. That's not allowed in Georgia, is what Burbach says. And what your injunction does is exactly that. He can't work for Champion in any capacity. And Burbach, I think, says you can't do that. And that was on a 120-mile radius.
As opposed to global or North America, Canada. Right.
So there's some really good law out there that has come down recently. I think that really goes to the heart of the issues in this case. Again, we filed our appellant's brief on Wednesday. And I don't have a cite to that Burback case in front of me, but I can get
I'm not going to go read it now anyway. It's not in my hands. It may be dropped in my hand saying, even though you followed our advice, we've changed our mind. You poor trial courts. When we change our mind, you're wrong.
Yeah,
So,
they do that sometimes, unfortunately.
sometimes.
But no, so that's up there. It does, I think, directly relate to the issues we've been litigating here. And we'll see what the Court of Appeals does.
All right. Mr. King, good morning. Anything new for Champion?
We filed a motion to dismiss a couple of the counts in the complaint. The response is probably not due for another 3 weeks or so. But since we have a moment, one of the things that I asked for that in connection with the relief is that there's a claim that's asserted as a Rico count, and federal court systems in dealing with Rico have essentially said or a number of courts have said, that because of the oppressiveness of the Rico allegation as to all of the parties, that the plaintiff should bear some additional burden at the start of the case to justify a Rico claim. And
Sort of a pleading plus. It's not just enough to say, hey, we think we could prove it later on, but here's a little discovery pack attached to.
yes, Your Honor.
Okay.
And it's called a Rico Statement.
Oh.
And a number of courts have adopted the Rico Statement. It's a series of form interrogatories that says, what's the crime, who committed the crime, when the crime was committed. In other words, a great amount of detail in order to justify whether a claim should go forward. And we attached a copy of a draft certificate to our motion. It's not part of the motion to dismiss. We did not move on that issue specifically to have this certificate done, but otherwise we did ask the court to take a look at the certificate and determine whether it be appropriate at this stage for the plaintiff to fill out those interrogatories.
So I'm just looking at the docket now, and I see May 31 was the filing of the motion to dismiss. Is there a separate?
It's attached to that motion.
It's just part of it. So if we're looking through the motion, it's dismiss count 5 and 7. P.S. We think there ought to be this RICO certificate. Is that a federal thing? It's in some federal jurisdictions, or Delaware does this?
So I took it out of, years ago, I took it out of a book called Hague, which is an 8-volume on every type of lawsuit you can bring under a federal code section. And I think I quoted in the papers that Hague says that this is something that's been adopted. And I've asked for the federal courts here to do it. I mean, the Northern District has not specifically adopted as a rule, but there's no prohibition.
What's your batting average in getting a court to say, yes, Mr. King, let's do that RICO certificate?
One for one.
Okay, you're batting 1,000. All right, good to know. All right, Mr. Schneider, how are we doing with getting well, 2 things. I can't remember with whom Ms. Gabrenia works. She's not connecting, and Ms. Barnes says she's not connecting, meaning she can see but not hear. Mr. Lay can hear and see what's going on. We know Mr. Powers can. So I don't remember which teams they're on. You may want to reach out. But now Ms. Gabrenia is in, and she is with you, Mr. Schneider. So good to go. And I'm less worried if it's co-counsel because we've got folks live here. If Mr. Powers couldn't see or hear what's going on, we'd need to get Starlink to help out. What's going on with the court reporter? That's actually what I meant to ask.
Gallo just called. The court reporter is logging on right now.
Great. From your office.
I'm not sure of that,
Okay.
but
Probably more comfortable there. There's a phone number I don't recognize. It's a 786.
This is Johnine Barnes, Your Honor.
Okay, that's how she's patching in. Great. Mr. Schneider, how do you envision this morning going when we do get up and running? I know there've been some stipulations or agreements in terms of foundation, which I appreciate. Things are what they are. It's not a trial. If there's a text or an email, let's just talk about what's in the text or the email, and we're going to be able to do that, which is great. But what was your plan for this morning so that we can see if there's any objection to format? We can be talking about that before this court reporter plugs in.
Really, I was just planning on, I've got a opening and a presentation prepared. Mr. Brenia will be putting up some slides that reflect a couple highlights from various transcripts and from the text and WhatsApp messages that were in Mr. Bailey's affidavit that's been stipulated to the admissibility of. That's really about it. I
Okay.
kind of imagine you have questions, or
I will.
I would then respond to these.
Okay, great. Mr. Kapler, does that basic approach work for you?
Judge, it does.
Okay, great. And Mr. King?
Yes, Your Honor.
So everything is in that same Williams directory. You've used, we had a Williams directory already, and oh, you got rid of the old one? Oh, okay. So it's in a hidden place. So everything in the Williams industrial directory relates to this. Oh, great. Okay. And Mr., is it pronounced Huff?
Yes.
He's here, or he is available, or you'll be speaking for him?
I'll be speaking for him. I don't know if he's on or not.
He doesn't need to be. I just was reviewing and remembering that this is an effort. Looks like Ms. Bradley is on, which is great, our court reporter.
He may be in Mr. Hernandez's office.
Okay. Ms. Bradley, will you let us know when you're ready to go?
Yes, I will. Give me 1 second.
That's fine. Take your time. Just give us the high sign.
I will. Sorry about that.
No problem. Wonder if Tamara is showing up today. Okay. Forgot about that. She what? Oh, she's not feeling well? Oh, she should stay away. That's an easy one. It's interesting.
The judge.
Yes, ma'am.
Before we start, I just want to make sure that I have everybody's names.
We'll do that. I just needed you to let me know you were ready, and then we can have everyone who will be speaking introduce themselves and let you know we've got 3 different parties here. And so they'll need to let you know I'm with plaintiff, I'm with defendant Powers, or defendant champion.
Okay, perfect. Well, I'm ready to start.
Okay. Well, why don't we first figure out who we've got here, and then we'll get on the record. So on behalf of Williams Industrial Services Group, who will be having a speaking role or be referred to at some point. So Ms. Bradley knows who's in the mix.
Sure. This is J.A. Schneider and Leslie Susan of Thompson Hine. Our general counsel, Chip Wheelock, is here as well, but he will not be speaking today.
Okay. And then Ms. Gabrenia won't be speaking. You'll be doing some sharing screens. She'll be the silent partner.
That's correct, Your Honor.
Okay. So primarily you, Mr. Schneider.
Yes, sir.
Okay. Got it. On behalf of Mr. Powers.
Good morning, Judge. Aaron Kapler on behalf of Michael Kelly Powers, and my colleague Jeff Reynolds is here with me as well.
Great. And Ms. Bradley, Mr. Powers is on this call as well, virtually. He's not here in court. And it may come to pass that I've got a question for him, or his lawyer wants him to expand on something because Mr. Powers is closer to that information. So Mr. Powers, the named defendant, is available should he be called upon. And on behalf of Champion Painting, and a few more words.
Michael King with Greenberg Troy on behalf of Champion Painting Specialty Services Corp. And we're joined remotely by my partner, Johnny Barnes.
And Ms. Barnes is able to, I think, see us. I know she can hear us. She is on partly by telephone, but it may become appropriate at some point for Ms. Barnes to chime in. She's remote, but is one of the co-counsel for Champion Painting. Does that get you, Ms. Bradley, what you need?
Yes. I may need to ask, or if whoever is appearing remotely, if you could please put your contact information in the chat, be very helpful.
Great. They'll take care of that. All right, let's go on the record. This is 2022 CV 358743, Williams Industrial Services Group, Inc. versus Michael Powers and Champion Painting Specialty Services Corporation. We are here today, the 13th of June, to talk about a motion for contempt that the plaintiff has filed. Filed about 3 weeks ago, May 26th. And it is a byproduct of plaintiff's review of Mr. Powers' personal devices. It's plural. I know there was an iPad out there. We had lots of conversations about the iPad. And Mr. Schneider can make clear if there were other devices and their provenance. It sounds like the provenance is Mr. Powers. In the motion, Williams argues that Mr. Powers has violated the TRO by working for Champion, his new employer, in ways that exceeded the scope of what I thought we had defined, which is working on a project. I think it was in Michigan. It's not in Georgia. It's not in Florida. It's not at the Braves game, and doing only that. And then subsequent to that, violating the preliminary injunction, which is on appeal, by actually continuing to do work for Champion because the injunction said you can't do that. And I appreciate that's on appeal, and there is fresh case law that says maybe the injunction was overbroad, but it's the injunction, and it was clear. So we're going to work through what these allegations are, what supports them. And Williams's motion, as I understand it, extends to Champion and Mr. Huff, who's vice president at Champion, because they were parties to some of these violations, and they were well aware of the scope of the TRO and the preliminary injunction. That's my tentative preliminary finding, that they were well aware. I'd be shocked to hear evidence that they weren't, at least Champion, because of course their counsel has been involved with all these discussions. And I think Mr. Huff was involved with some of them, but we'll get to that. So Mr. Snyder, I'm going to turn it over to you. In terms of time frame, we're going to need to stop a little before noon. I told you all we'd have 2 hours. We've used up a half hour of that just trying to get started, but I can go until about noon if we need to go that long, but not longer. So hopefully we can cover what needs to be covered. Before we go any further, anything preliminarily, Mr. Snyder, about what I just covered or what you think we're doing this morning?
I would only add to that Ms. Barnes represented to me in an email that Greenberg Traurig also represents Mr. Huff individually, and that he is, I believe he's here. I don't see his name up here. I think they said he's with Mr. Hernandez, but in any event, that he has been apprised of at least the motion for contempt in this hearing.
Okay, and we'll hear from Mr. King on that, or Ms. Barnes, or Mr. Hernandez when we get there. But thank you for flagging that he's not pro se for purposes of what we're covering today. Mr. Kapler, anything you want to add just preliminarily?
No, Judge, I'm ready.
Great. Mr. King? All right. Can we confirm that Mr. Huff is able to hear what's going on?
Carlos, can you confirm?
It's fine if he can't, as long as he's got representation here. He may be choosing to not be here and be unrepresented. But it has been represented to me that Mr. Hernandez may be sitting in a room with Mr. Huff.
Yes.
The Greenberg Traurig team has been having technical difficulties. Your CIO needs to be doing something. Ms. Barnes, do you know anything about Mr. Huff's whereabouts?
I don't know if Mr. Huff is attending. Mr. Huff did receive notice of the hearing. Mr. Hernandez is on as a representative for Champion. There was no indication that Mr. Huff needed to be here. So we do have party representation through Mr. Hernandez.
Perfect.
And I don't know if Mr. Huff is with Mr. Hernandez. I cannot make that representation.
Okay, and I didn't either. Mr. King thought he might be there. He may not, and he doesn't need to. I'm neutral on that. I'm just trying to understand who all is in the mix. So if you all learn more about it, you can put it in a chat or get word to Mr. King and he can tell me, but I think we're ready to go forward. So Mr. Schneider, your microphone.
Thank you, Your Honor. And I guess we had done this before. Is it okay if we remain seated for?
It is. You can be seated. You can be at the podium. As long as Ms. Bradley can hear you. And the way the system works, if you're in front of a microphone with a green light on it, you're good to go. If you stray too far from a microphone with a green light on, your words may not get taken down.
Okay.
I'll hear them, but she may not.
Thank you, Your Honor.
Yeah.
Okay. Just as an initial matter, I found it interesting that Mr. Kapler raised the issue of the appeal. As Your Honor pointed out, the injunction is in place. It is what it is. I have not read the case Mr. Kapler is referring to yet. I do note that it's interesting that the in any capacity argument was made ad nauseum in this case, both at the TRO hearing and then later at the preliminary injunction hearing. And after the temporary restraining order hearing on January 20th, on January 24th, you entered that TRO and you did give him a window where he could perform certain services. Up at one particular, I believe there was discussion about whether there were specialty safety coding services. There was some dispute about whether Williams even did that work, but in any event, he was to be restricted to that work at the Enrico Fermi plant up in Michigan. The evidence is crystal clear here. He paid no attention to that restriction, which is exactly why the in any capacity argument is largely a red herring. Because as a law school matter, maybe. In the real world, everybody knows what's going on. In any event, I filed this motion for contempt on May 26th, and I kind of want to start with something that I find a little bit telling. That was 18 days ago. Since then, I haven't heard a word from counsel for Champion or from counsel for Powers or Mr. Huff that, hey, JA, there's some misunderstanding here. You're reading something into these messages that's just not there. Or we didn't understand the TRO. Mr. Powers didn't understand what it was. Mr. Powers didn't understand what the preliminary injunction meant. Or Champion wasn't aware this was going on. And now we're going to put a stop to it. Haven't heard anything like that. Haven't heard anything about any discipline. I'd asked several times whether he was being paid or not. I got no response to that. But here's what I have got. And Natalie, if you could put up, please, Mr. Powers' response to plaintiff's second interrogatories, page 3.
And before she puts that up,
Sure.
is there anything, Mr. Schneider, you think you're going to be asking to, we'll call it publish, just because we're all going to see it, that is going to cause Mr. Kapler or Mr. King to say, wait, that's not something that we said. Obviously, something from an interrogatory is fine. That's not an issue of, we've never seen this before, where did it come from? But just so we can flow smoothly,
Sure.
You've got a pretty good idea of what you're going to ask Ms. Gabrenia to share on the screen. And I appreciate again that the parties have agreed, don't worry about foundations and whatnot. But you're trying to push hard here, as you're right, frustrated by what you think has happened. I just want to avoid nope, take that down. We've never seen that before. So as you think through the presentation, anything that falls into that category?
Everything I intend to put up is either in an interrogatory response, in a hearing transcript, or some of the messages at issue.
Okay, and these would be things that Mr. Bailey helped extract from what you obtained from Champion or Mr. Powers?
Yes, Your Honor. And then, I'm sorry, and 2 excerpts from, one from Mr. Powers' affidavit, one from Mr. Huff's affidavit
Okay,
that have been filed.
great. So some of it you're just putting back in front of me what's in the record, and then there's a bit that has been discovered during discovery.
These, I'm thinking of what I'm putting up here as demonstratives.
Yep. Okay, great. Thank you.
Thank you. Yeah, there we go. And we received these, I think, Wednesday night. I was out of town last week. This is Mr. Powers' response to plaintiff's second set of interrogatories, number 2. And the question is, describe your relationship with defendant now and since the entry of the preliminary injunction entered in this matter on March 2nd, including whether you are receiving or have received compensation in any form from Champion, and whether you are performing or have performed work on behalf of Champion. And the answer here is, after we get through the objections, after the preliminary injunction was entered on March 2, 2022, he was terminated from employment with Champion. Since the preliminary injunction was entered, Champion has provided payment to Mr. Powers of $4,870.70 per week. Champion, the entity, has not asked Mr. Powers to perform any work on behalf of Champion.
So this is actually Mr. Powers' response. And in it, he actually doesn't say if he's doing any work for Champion, but he says Champion has not asked me, meaning Mr. Powers, to perform any work.
That's correct, Your Honor.
Okay.
And Champion has an identical response.
Literally, like word for word?
Literally word for word, except that Champion acknowledges that they're also paying Mr. Powers an additional $3,000 per month as an allowance. I don't think I've ever seen a scenario where someone said, I'm not working for this company, but they're paying me a full salary. They're even giving me allowances for what I can't imagine that would be if I'm not working for them. And he is working for them. The evidence is crystal clear that he's providing services to them. The way they parse this, that Champion has not asked Powers to perform work on behalf of Champion. I'm sorry, Champion has not asked Powers to perform work on behalf of Champion. The question was, whether you are performing any work, or have you performed any work since the preliminary injunction? They don't answer that. They don't answer that because I imagine their lawyers aren't going to let them put that in an interrogatory response when it's this crystal clear that it's not true. And I don't even know what that means. Does that somehow excuse it? That I guess I go to work every day and I get paid. If they don't ask me to do anything, does that mean I'm not employed by them? We are in 9/15/14 country here. There is a complete absence of any justiciable issue of law or fact here. He has remained employed. They're paying him. They're paying him an allowance. All they're saying is it's not even true that they didn't ask him anything. When we get ahead to a little bit of these threads, it's clear that Mr. Huff is asking him for things. But setting that aside, he's still working there. This is just, it's egregious. We've been in front of you. We've been in front of you now. This is the fourth time we're back here. I still haven't heard nothing about let's figure something out. Let's not waste the court's time anymore. Why are we here?
I thought briefly there was some hope after the injunction things might resolve and you all would go away.
There was.
Okay, so there was that little hope. Ms. Niles told me, that would be great. Didn't work out.
Understood.
Okay.
I can tell you why we're here. Because Powers and Champion and Huff and the executive team over there, they've done the math. They've determined that it's worth it. They've determined that it's worth risking whatever they think you might throw at them, or that maybe they'll get a slap on the wrist, or maybe they won't get caught. To them, it's worth it. They're going to make millions of dollars and take their chances. It's just an injunction. We don't have to worry about it. Since the preliminary injunction was entered, counsel has told me at least twice that Powers and Champion were complying with the injunction. In the best case here, they've been misleading their attorneys. There's no alternate legal theory where this conduct is not a clear violation of the preliminary injunction, and the conduct that occurred prior to March 2nd, but after January 24th, wasn't a clear violation of the TRO. There's no universe where Greenberg-Traurig told these guys, hey, this is okay, go ahead and do it. There's no universe where Thompson O'Brien told Mr. Powers, go ahead, keep working. Don't worry about the injunction. We'll figure that out.
You're going to get to the keep working part, because keep getting paid is different from keep working. Getting paid may be a problem in and of itself. And it'd be interesting to hear how Champion is treating those payments for tax purposes and how Mr. Powers is treating those payments for are those salary and wages? But that's different from also then doing work for. And of course, the language here crafted by lawyers, Champion didn't ask Mr. Powers to do any work. So I assume you're going to get there, but you keep saying, and he's still working for them. But if your evidence of working for them is that he gets paid, I don't know that that means he's doing work for them. It still might be a violation of the preliminary injunction, but it's a softer violation than here's an example of something Powers did on behalf of Champion. And unfortunately for him, he doesn't have the ability to say, well, I was doing it out of the goodness of my heart. I actually was getting almost $8,000 a month to do this thing that the electronic discovery showed that I did.
Absolutely, Your Honor. And prior to receiving these discovery responses, I didn't have absolute proof that he was getting paid, but I don't need proof that he was getting paid for him to be working for Champion.
Sure.
He could be anticipating he's going to get paid next year.
Right.
He could be doing it because he's independently wealthy and he doesn't care and he loves the guys at Champion and he hates the guys at Williams and he just wants to beat them. It's a violation of the preliminary injunction. One thing you'll notice, and we'll get to the evidence. It's interesting, and every time I look at this, I keep finding and noticing new things. The communications prior to March are text that we've been able to uncover were text messages. Starting in March, the messages that we've uncovered are on WhatsApp. Well, why is somebody using WhatsApp after they've been texting? It's crystal clear. They were well aware of the orders. They're well aware of the risks, and they were well aware that they were being watched. And there was at that point, after the February 25th hearing, we had a lengthy discussion at the end of that day about the forensics, and all of a sudden they switch over to WhatsApp. Why? It's telling. So the TRO was crystal clear that was entered on January 24th. For 30 days, defendant Champion may utilize defendant powers solely and exclusively as a supervisor of the work Champion is performing at the Enrico Fermi Nuclear Generating Station in Newport, Michigan. Powers may not work in any other capacity for Champion during this period. Likewise, the preliminary injunction was crystal clear. Powers and anyone in active concert or participation with him, including but not limited to defendant Champion or its agents, are hereby enjoined from taking any of the following actions: continuing to work at defendant Champion or any of its affiliates or related entities in the United States and Canada. There's zero doubt. Mr. Huff, Mr. Powers, these guys make hundreds of thousands of dollars. They're engineers. They are sophisticated business people. They have sophisticated lawyers. To the extent there's no argument that any of that was unclear. But these aren't guys off the street. These aren't hourly workers who've never read a contract, who've never seen legal documents, and they had sophisticated lawyers. They knew exactly what these injunctions said, and if they had any doubt, they could have asked their lawyers. Natalie, if you could put up slide 2. This is from the TRO hearing on January 22nd. Page 43, and I'm reading the highlighted portion here. If they conduct discovery and find out Mr. Powers is doing other things other than specialty coatings at that one site in Michigan, they will be back here and you can say, you know what, you misrepresented things you were saying, but that isn't going to happen. The only thing Mr. Powers is doing is at that single site in Michigan. Natalie, slide 3, please. Again, following up on that, on January 20th, page 44 of that transcript, down at line 21. Mr. Powers isn't responsible for decommissioning at Champion, so that's not within his realm anyway. His only responsibility is that specialty coatings on that single site. 2 days before that hearing, Natalie, if you could put up slide 10. 2 days before that hearing, Mr. Powers told you in an affidavit, my current role with Champion at this point is limited to this specialty group, and even more so, limited to work at a single nuclear plant, Enrico Fermi Nuclear Generating Station, located about 40 minutes away from Dearborn, Michigan. Mr. Huff, slide 11, please, Natalie. Mr. Huff's affidavit submitted 2 days before that hearing, paragraphs 13 and 14. In his current role, Mr. Powers works at the Fermi Nuclear Power Plant based in Michigan. Mr. Powers supervises and oversees Champion's work at the Fermi Nuclear Power Plant. On February, 4 days after this hearing, on February 24th, you entered the TRO. Slide 4, please, Natalie. Is that okay? I'm sorry. You entered the TRO on January 24th. This is from the preliminary injunction hearing on February 18th. Mr. King tells you that Huff will confirm in his testimony that Powers is going to be kept in that penalty box. There was a lot of discussion about the penalty box. Slide 5. On February 18th, this is again at the preliminary injunction hearing on page 251 of that transcript. Mr. Kapler elicits this testimony from Mr. Powers. Question, since you've been at Champion, have you performed anywhere on the Holtec project? Answer, I have not. Question, have you done any work since you've been at Champion on any project other than the one in Michigan? Answer, since the TRO, I have not. Slide 6, please, Natalie. Mr. King, at page 253 of this transcript, asks Mr. Powers, you understand the TRO not only prohibits you from doing anything outside of that one project in Michigan, Enrico Fermi, but indirectly as well? Answer, yes, I do. Have you attempted to do anything since January 6th that would indirectly affect or compete with Williams' business? Answer, I have not. Slide 7, please, Natalie. And again, at the February 25th, the follow-up preliminary injunction hearing on transcript page 79 and 80. On cross-examination, Mr. Huff told you, Carlos Hernandez was intimately aware of the TRO and all these proceedings. He directed me to ensure that Powers adhered to the TRO and that Kelly needs to stay in the penalty box and do the work at Fermi. This is just a sampling, Your Honor. It's by no means everything you heard on those days that wasn't true. We have a defendant here, Mr. Powers, who has no respect for his contractual obligations, his legal obligations, the court's authority, or the oath that he took when he testified. We've seen that in his actions, his testimony, and now these recently uncovered messages, where his lack of respect for the court is both clear implicitly through his actions, explicitly through what he says in those messages. We have another defendant, Champion, and at least one of its top executives, Mr. Huff, that seems to care nothing for any other company's contractual rights, trade secrets, confidential information, and also ignores the court's authority. This is what the court's contempt powers are for. This is why you have contempt. I don't need to tell you that, Your Honor. I know you know that. This is why you can hold people in contempt. It was Mr. King that told you on February 25th that one of the ways you can enforce your order, if Mr. Powers and Champion doesn't obey, you can put them in jail. Getting back to the violations, the TRO entered on January 24th, restricted powers to supervising Champion work at the Enrico Fermi Nuclear Generating Station in Newport, Michigan. There's no doubt about that. Now, I realize the TRO was eventually superseded by the preliminary injunction, but that doesn't mean you get a free pass because you essentially, Your Honor, essentially expanded the relief of the TRO. And it shows a pattern of practice of what's going on here. I'm going to show you now a series of text and WhatsApp messages, Your Honor. And they can be found in the record. All of this can be found in the record in the third affidavit of our forensic expert, Scott Bailey, which is attached to our brief in support of the motion for contempt at Exhibit A. Before we get into that, I just want to remind the court of the names of some of the players. I know you haven't lived with this case for 5 months the way we have.
Before you do that,
Sure.
which is helpful, and I appreciate that. Tell me again where this Bailey affidavit is.
It is at, sorry. It's Exhibit A.
Attached to the brief.
Yeah, I'm sorry.
Okay, so plaintiff's brief with exhibit. Whoa, the 17 megabyte file.
I'm sorry about that, Your Honor.
That's right. Oh, yeah, this one has redactions in it, so I should look at the unredacted one. Unredacted exhibits. Okay, so third affidavit of S. Bailey. Yep. Okay, I just wanted to have Mr. Bailey's affidavit in front of me, and I've got it now.
Thank you, Your Honor. So just as a recap of some of the names and players, you know Mr. Powers, obviously, you know who Champion is. Mr. Huff, if you'll recall, as a vice president at Champion on Champion's executive leadership team. You may recall he testified remotely on February 25th. Mr. Huff was the one he noted he worked 7 days a week.
I heard from Mr. Huff and then a gentleman from Holtec.
Holtec.
Yeah.
Kelly Trice.
Okay.
He was coming up next on my list. Mr. Huff was the one who interviewed and hired Mr. Powers. And if you recall, wrote the initial letter reaching out to Holtec on November 23rd, the day Mr. Powers signed with Champion. I'll skip ahead since you mentioned him. Kelly Trice, he also testified on February 18th. He was the CEO of Holtec. Holtec, if you recall, is the key decommissioning customer that was really at that time, and probably still is, at the center of this dispute. They're not the only customer. You'll see another customer referred to Energy Northwest in some of these text messages, and I'll refer you back when we get there. Indian Point, Oyster Creek, and Pilgrim. Those were three nuclear generating facilities where Williams was performing decommissioning work for Holtec, where after Mr. Powers left and went to Champion, Champion is now doing the lion's share of that work.
And if I'm remembering correctly, Holtec doesn't own or operate or control those nuclear facilities. Holtec had the contract from Public Utility X to do the work, and Williams would have been a sub for Holtec. But then Williams wasn't, and Champion was, or there was some transition that your client felt was a byproduct of Mr. Powers leaving Williams and going to Champion.
Correct. Holtec has a project at the nuclear station. They don't own the nuclear station. Yeah. And then they hire Williams or subsequently Champion to do that work or parts of that work.
And it's all decommissioning work, or was some of it specialty coatings? The nuclear operations were up and running. They just needed new special paint on their pipes.
To my understanding, none of that was specialty coating work. Certainly the work at issue in this suit was the decommissioning work. You'll also hear a little bit about something referred to as pool to pad work, and that's got to do with moving fuel from one place to another.
Okay.
That is actually work that Williams so far has been able to hang on to from Holtec, but unfortunately, well, we'll get to that, and I'm not going to predict the future on that. Right. So Mr. Trice was the CEO of Holtec. Jim Carter is another name you'll see quite often. Mr. Carter was a former Williams employee who now works for Champion, and Mr. Carter, if you may or may not recall, it didn't seem a huge point at the hearing, but he had met with two other Williams employees who had resigned with virtually no notice around New Year's. they had a meeting out in Conyers to go over the Gantt chart, which was the roadmap document created by a Mr. Anderson, who I'll get to in a second.
That's the consultant.
Mr. Anderson was the consultant. Right. So you've got Mr. Anderson, who was next on our list.
And he is not and was not ever a Williams employee because if I'm remembering correctly, one or both defendants pointed out Anderson having something doesn't mean it's a Williams thing. That was an area of disagreement, or at least highlighted by one side, de-emphasized by the other. But Anderson did work for Williams, but was not a Williams employee.
Williams was I believe, a long-term Williams employee. I know he was a Williams employee. Anderson.
Okay.
He became a consultant around the time of the restructuring of the business.
Mm-hmm.
He was put on a consulting contract. The relevant time period, he was a consultant. But prior to that, he had been an employee of Williams.
Making him a particularly valuable consultant to Williams because he had been there so long, and also a repository of lots of information about Williams because he had been there so long.
I would agree with that, Your Honor.
Okay.
Mr. Anderson is on some of these text chains. The other name here that I think we'll see is
Mr. Anderson, someone had put together a PowerPoint saying, these are all the competitors in these fields. And Williams wasn't on one of those slides, and folks got animated about that. Was that an Anderson PowerPoint or someone else? Do you remember what I'm talking about?
I think what you're referring to is Champion wasn't on that slide.
Or Champion was. It was evidence that people weren't competitors because
Sure.
it was listing out, here's who we need to worry about or buy or join forces with. And somehow the pieces didn't line up. And that lended credence to an argument that our Champion and Williams even operating in the same spaces. Was that an Anderson document?
Sitting here today, I can't tell you
Okay.
that was Mr. Anderson.
It doesn't affect what I'm just trying to place hats back on these people that
Sure.
you're describing.
Sure. So with that, and you recall, Enrico Fermi was the power plant in Michigan. That was the penalty box during the duration of the TRO. Natalie, could you put up slide 18, please? So on February 9th and 10th, this is 2 weeks after the TRO was entered. Mr. Powers is supposed to be in his penalty box supervising Champion work at Enrico Fermi only. Here he's supervising Mr. Carter. Okay, headed to dinner with the Pilgrim staff. We'll call you afterwards. That's on February 9th. On February 10th, do you have any objections to the pending resolution at PIL? That's Pilgrim. I'd like to circle back to Moylan, thanking him for his leadership. No objections at all. That's Mr. Powers' response. So what's going on here? Well, one, he's obviously working with Carter. Two, it's got nothing to do with Fermi. Carter is asking Powers for approval of the pending resolution at Pilgrim, one of the sites where Champion took work away from Williams.
Moylan would be a Holtec person, a Pilgrim person, don't know.
I do not know who Mr. Moylan is. But I know it doesn't have anything to do with Enrico Fermi.
It doesn't look like it.
And I know it's directly related to the Holtec work that Champion took from Williams. So that's strike one.
So Carter is, you said this already. Okay,
Sure. You good with Carter?
I'm good.
Okay. Natalie, slide 13, please. Here's a series of text messages between and amongst Carter and Powers, and then Carter, Powers, and Anderson from February 11th, 2022. So this is the next day. And one thing that's notable here is on February 18th, and I don't have a slide of this, but on the transcript of the February 18th hearing at page 81, 82, Mr. Powers was asked if Mr. Anderson worked at Champion. And the answer was no. He's not employed by Champion. So what's going on here? Carter to Powers on February 11th. Carter's telling Powers that there's labor problems in New York and Trice needs to make some phone calls. Oh, and I'm sorry. And he needs to call Trice. Well, no, he says that, I'm sorry.
Trice needs to make
some phone calls. It's right there. The electricians are saying they're not going to show up on Monday. Couple hours later, Carter follows up. This time he includes Anderson, gives more details, clarifies that he's talking about Indian Point and not Oyster Creek or Pilgrim. That's the at IPEC. No issues at OC, Oyster Creek, or Pilgrim. Powers acknowledges at 3:59. Got it. I will call Trice. Less than 2 hours later, Carter comes back to Powers and Anderson. Just heard back from Capurzo. All good now until February 28th. He said, whatever I did on my end is appreciated. Mr. Powers responds with a thumbs up.
So from your understanding, and if you're purely speculating, just say, I can't answer that. Why can't Carter call Trice? Why does Powers have to call Trice? Is there I don't remember Carter's role at Champion. Just know he went from Williams to Champion, and he and Mr. Powers know each other. Why is it that Mr. Powers needs to call Trice as opposed to Carter?
Well, I think the obvious answer is that Mr. Powers is the one that has the relationship with Trice. And I think it's clear from the face of these text messages and prior text messages that.
Because Trice is at Holtec. Trice isn't someone above. I just had wires crossed. He's not someone above Powers at Champion. He is at Holtec.
That's correct. He's the customer.
Yep.
And so Carter, for whatever reason, feels he can't call Mr. Trice.
Yep.
But Kelly Powers can.
Yep.
Kelly Powers, who's supposed to be just working at Enrico Fermi, not talking to Kelly Trice, not talking to customers, not talking to Holtec. So that's strike two. There's strike two on February 11th. Natalie, could you move to slide 14?
These slides are from what? Is that an exhibit that I also have, or you put together I don't know what this piece of software is. You put together a something and you've just numbered some slides.
I have just numbered slides. These are PDFs. These are excerpts taken from Mr. Bailey's affidavit.
So I've got his affidavit, and there's this ginormous, it's not that long, but there's this, it's basically a table that lists, I guess, examples that he thinks are communications that ought not to have occurred per the terms of TRO and preliminary injunction. And you have pulled some of them, like the muscle arm one is the one that caught me. That's in here. And you have pulled some out and created a slide in whatever your software is.
Yes. What I'm showing you on these slides is reflected 100% on the affidavit.
Oh, and I wasn't doubting that. I just was curious if those slides existed in a document you have shared with Ms. Niles or with the defense.
These slides I have not.
Okay.
I'd be happy to.
I'll ask if I need them. I just wanted to know if they existed in that format in here. And I see the table instead in the affidavit.
Yeah. Ms. Susan just reminded me, we have hard copies too, if anybody.
Okay, I'm good.
The full set. Okay, thank you.
Okay. I'll pick up.
You got a clear one?
Thank you.
Yeah. So here we're seeing where his activities aren't even limited to Holtec work or at those three plants. This is where, and I mentioned this earlier, March 1, where
We're now on WhatsApp.
We're now on WhatsApp. And you may notice the first message that comes up when you start a WhatsApp conversation says messages and calls are end-to-end encrypted. No one outside of this chat, not even WhatsApp, can read or listen to them.
You may want a refund because here we are reading them.
Here we are. I think this pretty clearly goes to their state of mind at this point. But I will, I'll let the court draw its own conclusion on that.
Well, when you say state of mind, am I going to see stuff later this morning where Mr. Powers is reaching out to, I guess this is with Huff. So Huff is actually doing WhatsApp with Mr. Powers. It's not just Mr. Powers saying, hey, someone's going to be looking at my devices. I better use a different format of communicating. He has someone communicating back to him using that same format.
That's correct.
Okay.
That's correct. In this case, right. In this case, so it's Kyle Huff.
Yep.
This is on March 1st. So after the preliminary injunction hearing, after Ms. Niles had sent out an email to counsel asking for a draft of an order, which I understand is not itself an order. But the TRO is still in place here. He's still supposed to be restricted to Enrico Fermi. On March 1st, Mr. Powers tells Mr. Huff, JD Taylor at energynorthwest.com. He is the lead contract supply chain guy. He said, if we email him, he will provide instructions for us getting set up to bid work. Mr. Huff responds, okay. Doesn't tell him, hey, what are you doing? You're not supposed to be doing this stuff.
What does this have to do with Fermi?
What is exactly? He just says, okay. Another, I guess, coincidence. The Williams site manager on Williams project for Energy Northwest resigned shortly after this, or resigned very recently. So he, as far as I know, hasn't popped up at Champion yet. But I think it's clear this is in their sights. And it follows a familiar pattern of us losing people who did Holtec work to come over and work for Champion. And now we're losing people who do Energy Northwest work.
But is Energy Northwest a competitor of Holtec? In other words, they're sort of a general contractor at nuclear power plants, or is Energy Northwest a public utility?
Energy Northwest, I don't know, is there a public utility? They are an energy.
They're a public utility.
Okay.
Okay.
Thank you. Sure. So they're a public utility. They are a.
So this has, in theory, nothing to do with Holtec.
Correct.
It might get Champion work at a public utility, but it's not. Instead of getting work at a larger service provider to a public utility, this is going straight to the source. In other words,
Correct.
Let's try to get a contract directly with a public utility.
Right. And it's not necessarily the decommissioning work that Williams used to do and now Champion does for Holtec. There's all sorts of there's coatings, you heard a whole litany.
I don't think it matters what the work is. It's not Fermi.
Correct. On March 2nd, the court enters its preliminary injunction, crystal clear what it says. Powers and anyone in active concert or participation with him, including but not limited to defendant Champion or its agents, are hereby enjoined from taking any of the following actions. 1, continuing to work at defendant Champion or any of its affiliates or related entities in the United States and Canada. Natalie, could you please put up slide 15? So right off the bat on March 2nd, this is at 4:23 in the afternoon. We're still on WhatsApp. And this is in the same WhatsApp conversation, just at a different spot in Mr. Bailey's affidavit. Right off the bat, you've got notice to Huff. Judge ruled I cannot work for Champion until the end of my non-complete. I'm completely shocked. He then admits he's been working with Jim Carter prior to, in case that wasn't clear. I'm guessing I should not meet with Jim Carter and the contractor at the new office tomorrow. Not sure why he's shocked, but he's aware of the TRO. and he's aware of the preliminary injunction, and so is Huff at this point. And so as you read through this, on March 3rd, he's confirming that he's in the loop with Trice regarding labor issues. And
You
that's,
didn't highlight the what a wacko judge part.
I did not, Your Honor.
Mm.
He knows, but in any event, on March 3rd, now there's no question, he knows he's not supposed to be working for Champion at all. And he says, he's talking about Trice, keeps me in the loop on how to handle issues like the labor agreement negotiations. That ties back to the Indian Point discussion with Mr. Carter. And then he says, if you need to have a group call with him and you and Carlos for me to make introductions, I can arrange. So right off the bat, he's now saying, okay, well, I'll take my contact and I'll transfer it to somebody else. That's a violation of the order. That's an egregious violation of the order. It was a violation of the TRO. It's certainly a violation of the preliminary injunction. And why would he need to introduce Huff to Trice at this point? How has Trice not met Huff yet? Unless Powers was running that relationship. In any event, that's strike 4 with regard to your orders, strike 1 with regard to the preliminary injunction. Does it stop there? No. Natalie, slide 17, please. March 11th, Powers is now working directly with Huff to recruit former Williams employees to come work for Champion. This is Randy Gasser. On March 11th, I sent you an email on your AOL account to Rusty Gasser. I'm not sure why he's sending emails to Mr. Huff on Huff's AOL account, which we weren't even aware of, unless they're trying to hide something. Mr. Huff says to Powers,
Mr. Gasser in March of this year doesn't work at Williams anymore.
he does not.
So in March, you've got mail from Mr. Powers. That's not about someone who is an active Williams employee. It's someone who was a Williams employee.
Correct.
Any idea if Mr. Gasser left Williams with a non-compete?
Mr. Gasser did not have a non-compete. We're not here questioning whether Mr. Gasser could go work for Champion.
It's why would Mr. Powers, who's not working for Champion, although being paid $8,000 a month, be helping Mr. Huff land this person? And it may sting a little bit to Williams that he's a former Gasser is a former Williams employee, but Gasser's in the clear. He could go work for Champion regardless of how he was recruited and not be running afoul of a non-compete.
Mr. Gasser.
Yes.
Yes, correct.
Yes. Okay.
And so a couple points about Mr. Powers. I hadn't really expected to get into this, but one, he's working for Champion here. It's a violation of the preliminary injunction. 2, it's a violation of Powers' non-solicitation clause of his agreement, which I know is not technically part of the preliminary injunction. 3rd, well, that's enough. Those 2 points are fine. One interesting thing here is Huff says to Powers, I sent it to I assume he meant to say lawyers there, that we want to hire him. I'm not sure if he's talking about the message or if he's talking about he forwarded on the email. If he forwarded on that email to the lawyers, we've got a whole different set of problems here. But we can move past that for the time being. And you see in these emails, as you read down, Huff, where we've seen a representation already in the interrogatories that Champion didn't ask Powers to do anything, setting aside whether that's the standard. Huff is asking him, send me contact info. I need salary info. The salary info, and Powers, no hesitation, tells him what he's making. You might recall at the temporary restraining order, Mr. Kapler asked to file Mr. Powers' affidavit under seal because they had redacted out his salary information. So they know this is confidential information. Mr. Powers is no compunction about giving away that information, setting aside that everything he's doing here is in violation of the preliminary injunction. So that's strike 2 on the injunction. Strike 5 overall. Natalie, slide 16, please. Now, this is a series of WhatsApp messages between Mr. Powers and Mr. Carter. They've now switched to WhatsApp as well. Kind of as with the previous set, the content almost is immaterial. He's doing work for Champion here in violation of a preliminary injunction. What they're talking about here is pool to pad work. Peach bottom.
If you look at the
Sure.
bottom of the slide, Mr. Powers is going to check with someone or someplace. Do we know what SOLER is?
I do not know what that means, Your Honor.
Okay.
But WPS is Williams Plant Services. PTP refers to pool to pad work. And like I said earlier, that's one of the remaining pieces of work that Williams is actually still doing for Holtec. But clearly that is now in the crosshairs of Champion. In the 4th affidavit of Mr. Lay, he explains a little bit of this and notes that Champion has recently hired Williams' director of fuel programs, a guy by the name of Dave Sharrock. He was in charge of Williams' pool to pad work at all Williams sites that did pool to pad work, which included Pilgrim, Oyster Creek, Indian Point, among others. In Mr. Bailey's affidavit, you'll see at figure 8.1 through 8.3, I don't have a slide of this. On March 12th and 13th, Mr. Powers had 3 phone calls with Mr. Sharrock. Don't know what those are about. I'm sure they'll tell me everything they talked about at a deposition someday. But Mr. Sharrock resigned from Williams on April 1 and joined Champion almost immediately thereafter. So I don't know, in my view, that's strike 3 and 4 on the PI and at least strike 6 and 7 overall here. That's what we've caught. That's what we've got. This isn't, they turned over a whole bunch of emails and all this stuff and we got it in discovery through the normal course. We had to scratch this off Mr. Powers' iPhone, hire a forensic expert, go through, you recall, I think we interrupted your day once at a deposition to fight about this. That's how we got this. So it's impossible for us to know what the rest of the universe is on this stuff. What else is out there? What else could possibly be out there? What else is unrecoverable because things weren't preserved properly? What were just straight up phone calls from a different line? I don't know. This is what I know. I know he kept getting paid after March 2nd, and I know he kept working. So, and I know Mr. Huff was asking him to keep working. So, and that's not even getting into the number of lies or false statements that were made in various hearings or affidavits that have been handed to you. So that's what we're dealing with on the. Oh, and by the way, and this analysis ends March 21. March 21 was the date of collection.
Date of collection.
The date of that is the day we got the forensic image of Mr. Powers' iPhone. So obviously, after March 21, we have no idea what's been going on. That's also in Mr. Bailey's affidavit. If all of this isn't enough, and this is the one that I I really can't believe I didn't get a phone call or an email about this, or I didn't see an affidavit get filed on this one. The guy's stealing Williams Braves tickets. He took 7 sets, transferred them, or they were transferred to a woman that he is connected to on social media. I have no idea what he's thinking here. He couldn't possibly believe that he was entitled to use those tickets. The Braves didn't take him. Williams called at the start of the season. They said, oh yeah, Mr. Powers shouldn't have access to the tickets anymore. They took his name off the account. He didn't get, for some reason, he didn't come off the MLB app account. He couldn't possibly believe he was entitled to use those tickets. This is straight up theft.
These are tickets to games in this 2022 season, which started in April at the earliest, which would be unrelated to the different orders that were in place. Just he hadn't been with Williams for a while.
Right. What we've been told by the Braves is that it was March 25th and 26th that the tickets were transferred.
Okay.
It's all supported in the affidavits. Those are exhibits B, C, and D to our brief affidavits of Don Jenkins, David Carl, and Randy Lay at paragraph 6 and 7. And so you might ask, and it would be a fair question, well, why is this is egregious, but why is it contempt? You didn't order him not to take
Deal
Williams
from his former employer.
Right. And normally I might agree with you. But what he does with the tickets is he gives them to a former Williams executive who's now a consultant in the nuclear industry by the name of Tarun Ganirwial. And
That you'll spell for the court reporter at some point.
you know what? I'm going to spell it right now. Tarun. And the last name, Ganirwial, Ganerwial.
And how is it that you know to whom Mr. Powers transferred things? Because I think the first thing you said is he transferred everything to a female that you associate with him because of social media connections.
Correct. And so, well, Tarun, I'm going to use Tarun because it's just easier to say than Mr. Ganarwial. Tarun texted when Williams started to figure out what was going on. They started working with the Braves and said, hey, recall these tickets. These shouldn't be out there. And they got a text message from Tarun saying, hey, what's up with these tickets I got from Kelly? I've got clients coming in.
So Tarun says to Williams, yeah, I got these from Mr. Powers.
Yes.
Okay.
Yes. And Tarun is using at least 2 of the tickets to take 2 others in the nuclear industry that I am quite sure have no idea what's going on here. One is from a company called Enercon, who's in the nuclear services industry. The other is from a former Southern nuclear exec, and now the nuclear services lead for a company called Cohesive Solutions. I don't want to drag their names. Their names are in the affidavit. I don't need to drag them onto the record here because I don't suspect that those 2 fellows had any idea what was going on here. But why are you giving tickets to Tarun or to other execs in the nuclear industry? Because they're nice guys? You're building relationships. It's for business purposes. There's a reason King and Spalding has a suite at the Atlanta Hawks games. There's a reason I take clients to baseball games. There's a reason you can write that off on your taxes, at least part of it. So, what's Mr. Powers going to say about this? I don't know. He hasn't actually said anything about it yet. He hasn't put in an affidavit saying this isn't true. He hasn't even said, yeah, I did it. It was a mistake. But it had nothing to do with business. He hasn't done any of that. I can't believe that. But in any event, knowing everything else that I know about that and that I've learned in the last 6 months and that has been in front of the court, this is not a stretch why these tickets were being used. This is more, anything he's doing is in furtherance of his career and his relationship with Champion and to help Champion. So it's just another stick in the eye. So I'm basically at the end of my presentation here. I don't know if you have any questions for me.
I've been asking them all along.
Okay, sure.
Great. All right. I will turn back to you for any final word. Why don't we do this? If you would summarize now what relief you're seeking and why you think it's justified under contempt law.
Sure.
And you don't need to say, look at this exhibit. I've looked at all the exhibits. So you may say, for all the reasons I just shared with you, here is why, because you want contempt against 3 entities. And well, 2 people and 1 entity. And so hang some law or structure around what you've shared with me. I can see why someone could be riled up by what you've shared. Facially, much of it seems very inconsistent with the pretty clear terms of both the TRO and the preliminary injunction. I may hear to why it's not an issue in a minute, but you want relief. Why ought you get that relief?
Sure. Well, I'll run through the relief and then I can talk a little bit about why I think I'm entitled to it. First, a finding of criminal contempt against Mr. Powers, Mr. Huff, and Champion. 2, the maximum fine allowable by law against Powers, Huff, and Champion.
And the fine, as I'm remembering, is not much. And it is unlike civil contempt, where there's this ongoing, it would be a fine for each contemptuous act. So it would help me for you to say that would be each Braves ticket, and there were 50 of them, so that's $50,000. Or it's each line of the text message, or you need to unitize the situations.
Sure. So there's a few ways you can cut this up, Your Honor. I think probably the simplest from an accounting standpoint is the law allows you to find every day that someone is in contempt to be a separate act of contempt. And that's black letter case law. And so you could look at it as he was in violation. The evidence here would support a finding that he was in violation of the TRO starting from February 24th to, sorry, and I just got to.
Well, I mean, before you work too hard on dates.
Sure.
You have presented evidence that arguably on certain dates, there were communications showing that he was working for Champion when he wasn't supposed to. So something after March 2. Why are you saying, hey, I'll call this guy, or here's information about Gasser, whatever his name was. That's a day when that happened. I'm making it up now. 8 days before, you provided something that appears to show Mr. Powers is still working for Champion. Why would the 7 days in between also be $1,000 to be assessed against Mr. Powers and Champion and Mr. Huff? If there's no evidence, then on those days, well, I couldn't find something to do for Champion at that point because I've been told not to work for them. And so I'm more reactive. I'll get a text from Mr. Carter and then start doing some work for Champion.
Because there is evidence that he worked for them on these days, and that's he was getting paid. I know getting paid doesn't equal working for someone, but you can very easily look at the text message or the text or WhatsApp messages that we have and very easily conclude that he is still, you've got more than enough evidence to conclude he is working for Champion. And each day after the preliminary injunction was entered through, and I would argue through June 8th, probably through today, that he is working for Champion. And so that would be, I did the math yesterday, I think that's 120 days through today.
And your start date would be the entry of the preliminary injunction, because prior to that, working for Champion was fine as long as it was in the clear contours of the penalty box.
Yes.
Fair me only.
That's accurate. And I've got evidence, I've got hard evidence showing violations where he's outside of that penalty box. So the PI from there on, every day through today
Okay.
is where I would start.
Okay.
The TRO, we've got February 9th and 10th. And that February 9th and 10th, February 11th, where he's supervising Carter and Anderson again, and at least March 1. So you've got at least 1, 2, 3, 4 days there. I think the evidence is sufficient to show that he was talking to Trice, staying in the loop. We don't have those records, but we do know that was going on. I think those are additional acts of contempt that Your Honor could consider. But as far as what we've looked at today, I've got at least four days worth of violations on the TRO.
So criminal contempt for all three, the fine for Mr. Powers and Champion. How is Mr. Huff finable other than on specific dates where it appears they are Huff and Powers talking Champion work?
Because Mr. Huff is aiding and abetting this entire enterprise. He's obviously aware of the preliminary injunction, and he's obviously involved, and he's not putting a stop to it. Mr. Hernandez, he had testified, Mr. Hernandez had me in charge of making sure this guy stays in the penalty box.
Okay.
So who's in charge when he's during the preliminary injunction? He knows this is going on. He knows Mr. Powers is supposed to be restricted and shouldn't be doing this stuff. I would argue jail time is appropriate in this case. I know that's a lot, but you can do the math of 20 days times 120, and no one's asking for someone to be locked up for 8 years. But if there's a case that calls out for a harsh punishment, this is the case. These guys knew the risk. They knew the gamble they were taking. They knew what the order said, and they did it anyway. And frankly, a toothless punishment here teaches them all the wrong lessons again. We're already, we're already 7 months into Mr. Powers' non-compete that he appears to have ignored completely with impunity. So again, at the risk of, I'll just go back to, for all the reasons I've already stated.
Okay.
You
So
know,
based on the evidence you shared, you think criminal contempt, the fines you described, and jail time up to 8 years or whatever math that you did.
right, I'm not expecting 8 years.
Okay. Me neither.
Yeah.
But it's always good to explore the outer bounds.
I think that's what the law allows.
Okay.
I think the law supports that
Got it.
at this point.
Okay.
The other relief we would seek, there's a case called Stardust. Do you have that? I'm sorry.
Stardust, you cited for the provision that as long as the violation continues, for example, if being paid is proof of working for, then it's each day is a separate violation.
Right. And what the court did in that case was actually a little bit interesting. It found criminal contempt, issued an appropriate punishment, and then set I want to call it a bounty, but said for future, it set a price tag on future acts of contempt of $10,000 per violation. And the Court of Appeals actually upheld that as well.
How did they get to go more than 1,000?
That is what the court in Stardust did.
Wow. All right.
But in any event, you know, when you look at that, you know, criminal contempt versus civil contempt issue, the conditional punishments tend to be more appropriate in a scenario where there is a practical enforcement mechanism. So if, for instance, someone's not paying their child support, you will know when that child support gets paid or not. Or you tell someone you can't go within 500 feet of so-and-so. It's easy to show when that happens. Even a case like Stardust, they were selling items they weren't supposed to be selling in a part of town. They weren't supposed to be selling it without permits. City inspector can walk in there and pretty quickly determine. I don't have that luxury. The court doesn't have that luxury here. I'm finding this stuff out from March. I found this out about a week before I filed my motion. So with the time lag, even if discovery was a reasonable avenue for me to find continuing acts of contempt, how am I going to find that out? Starting today, I'm already 6 weeks down the line. We're into July, August before I even find that out. So it's the deterrent here is issuing a sanction with harsh teeth, and that's a fine. And I think jail time is appropriate in this case. You're also authorized to award attorney's fees here under 915, or I'm sorry, is it 915-14? 915-14. The Stardust case upheld an award of attorney's fees there based on the trial court's finding that the clear and blatant violations of the preliminary injunction unnecessarily expanded the proceedings. That's where I was going with the point early on today. This is the fourth time we're here now. And frankly, paying Mr. Powers and letting him provide services for your company, I don't see any legal theory where that is not working for Champion. And you can even take away, I don't even need the paying him, but when you throw paying him on top of this and your excuse is, well, we didn't ask him to do anything. Come on. Come on.
All right. Well, let me hear from Mr. Kapler and Mr. King, and I suspect that will help round the picture out some, but thank you for covering the relief piece. And we can go in either order you want, Kapler, King, King, Kapler, or you may have nothing to say.
I do have some things to say, Judge, but may I take like a 3-minute break to run to the facilities?
Sure. Let's reconvene in about 5 minutes.
Thank you.
Ms. Bradley, are you ready if we get started again?
Yes, Judge.
Great.
You
All right.
I'm sorry, I didn't mean to interrupt you.
That's okay.
I had two other items of relief we wanted to request.
Sure, I didn't mean to cut you short. I figured you were going to end with the bang on attorney's fees, which is going to be a bigger number than anything else I could come up with. But
Yeah.
what else do you have?
We'd like an order ordering
To
Mr.
follow
Powers.
the preliminary injunction? I thought I already did that.
Yeah. We think a forensic review of at least Mr. Powers' phones, laptops, any devices he is using, whether work, business, anything. And Mr. Huff's phones, laptops, any devices that either of them are using, whether business, personal, however they frame it, to be forensically reviewed at their cost, whether that's any of the defendant's cost. And also we would ask, and there's support for this in a case called Dinishgari versus Patriot Towing at 361 Georgia App 541, where after multiple violations of a preliminary injunction and contempt findings, the court struck the answer and entered default judgment on behalf of the plaintiff in a non-compete case.
So, couple questions about that. One, why would you need Mr. Huff's if you get Mr. Powers? You might learn that Mr. Huff is communicating with someone else, but I just worry that stretching things a little far, not a named defendant. I appreciate he's a senior executive with Champion and seems to be a central point of contact, but why not Mr. Carter's? There seem to be more exchanges with Mr. Carter than Mr. Huff. Maybe Mr. Carter didn't know about the preliminary injunction and the TRO, but again, the real smoking gun for you would be Mr. Powers communicating with someone, and if he's communicating with Huff, you get that from Mr. Powers' device. You don't need to confirm that Huff received it. So that's one question writ large, because I get nervous if we're starting to get into the, gosh, that electronic device, there's so much on there that has nothing to do with your work world. And so that makes me nervous, all the way up to the US Supreme Court makes them nervous. And so if you could get it through Powers, much less nervous about that, given what I've seen so far. Number two, if that's how we would travel, is you're going to learn about anything Mr. Huff may have done, emphasis may, post March 21 by peering through the lens of Mr. Powers' electronic devices. Why can you not get that as part of discovery? I'm not a discovery expert, but it would seem like there's an ongoing obligation to be handing things over. And you could always, just like you did a second set of interrogatories, hey, it's been a few months. We want another digital image of everything on all of Mr. Powers' devices, iPad, iPhone, Android phone, WhatsApp Prime, because clearly WhatsApp didn't provide the coverage he was hoping it would provide. How do you not get that without an order from me?
And okay, that was a long question.
Well, it was two. It's
Okay.
why do we need to get into someone other than Mr. Powers' device if really your angle is Powers? And there could be a theory, well, if Huff is talking to Trice, I want to know about that because Huff could say to Trice, Powers told me. But if Powers told Huff that, unless it's face-to-face, you're going to have an electronic trail if you get a good forensic grab of Mr. Powers' device. So why Huff, and why can't you get what you want from Powers' devices through discovery? Two small questions that I made complicated.
Sure. Well, one, I would say Mr. Powers has historically had a difficult time with preservation. And we're getting things late. We're getting things without metadata. We're getting things, or we're just not getting things. If you'll recall from the preliminary injunction hearing, there were any number of emails that we got from Champion eventually that we did not get from Mr. Powers. So that's one. Two, and so that's why Mr. Huff's devices are important. That's why, frankly, and I agree with you, Mr. Carter's devices are important. I could ask for everyone that Powers communicates at Champion. I would like all of those because I really don't trust anyone in this scenario. Even Mr. Huff is dealing with Powers on his AOL account. And you may recall some discussion at the PI hearing where there were things going to Mr. Huff's Gmail account. And then the only reason we ever got that was because someone inadvertently emailed it to Jim Carter's old email address at Williams. I don't know if you recall all of that specifically. So I don't trust that Mr. Powers and Mr. Huff, and I don't think any reasonable person would trust that Mr. Powers and Mr. Huff are operating above board here with regard to the communications. In any event, the way to cut through some of that is let's get images of both of their devices.
Okay. So you said you had two more relief requests. One is a forensic review of these devices. What was the other?
There's a case called Danishgari versus Patriot Towing, 361 Georgia App at 541, where the trial court, after multiple instances of
This is the dismissing the answer.
strike the answer.
Okay, right, striking the answer.
Judgment.
So that case helps with that, not the give you another image of a cell phone.
Correct.
Okay,
Correct.
got it.
Cite Smith versus Gwinnett County, 268 Georgia, 179, to support the equitable powers of the court to order the devices paid for, and those forensic reviews should be paid for defendants at this point.
Okay.
And then restitution on the
Braves
We
tickets?
were able to recover 6 of the Braves ticket sets. 1 set was used that we couldn't get back.
Okay.
So.
Anything else?
Okay. We asked for attorney's fees.
Got that.
Thank you.
You bet. All right. Mr. Kapler, had a restroom break. Maybe you found a good Glade air freshener there, because this doesn't smell real good for Mr. Powers right now. But I am confident you've got a perspective that's going to, as I said, round out the picture. We've only heard a little bit of it so far.
Thank you, Judge. And I want to start with the relief that they're seeking in terms of what they asked for today and what they sought in their papers.
Papers meaning the motion.
Correct.
Okay.
Yes, Judge. So in their papers, they say they want the court to issue the maximum fine allowable against Powers, Huff, and Champion. They don't seek incarceration in their papers. There's no incarceration order here. There's no citation here in terms of coming here to be subject to a potential incarceration order. So I don't think that's even available today because they didn't specifically seek it. And we were therefore not on notice of it or prepared to argue those issues. So I don't think that's even a potential. They did raise the fine, which we'll talk about in a little bit. But they also raised a number of things in their papers that they are not allowed to seek in contempt under the law. Now, they have appeared to have abandoned those today, or at least not raised them. But I think it's important to illustrate those because it goes back to the whole nature of their claims. This case was filed initially alleging there was some mastermind attempt to breach the non-solicitation provisions. They alleged that Mr. Powers and Ms. Wallace and all these other people got together to leave at the most inopportune time for Williams. That was false. We demonstrated that. That was an untrue allegation. And in fact, Mr. Lay, during his testimony, admitted he had no evidence to support that. That's how we started this case. And that's similar to how this contempt thing has evolved. Because in their papers, in addition to the fine, which again wasn't incarceration, they sought for the preliminary injunction to be extended for an amount of time for tolling. They're not entitled to that under the law.
So pause. Mr. Snyder, you didn't mention that. You were thorough. In fact, I cut you off because I thought you were done. You got through 7 forms of relief. I didn't hear you say number 8, extend the non-compete because it effectively has not been complied with. We want our year. When does that year start? When will Mr. Powers not compete? Because he hasn't not competed so far. Is that withdrawn?
I'll withdraw that. The Danishek case actually made that clear.
Okay.
I learned that after filing the brief.
We're always learning new things. So that's off the table.
Okay. The next
You're 1 for 1.
I'm batting 1,000 like
because there are a lot of strikes. It's pretty good to start hitting now.
Well, I think he had 7 strikes. So
that's 2 outs plus an extra strike.
That's right. So we're still working towards that. So the second thing they sought in their papers, which they didn't bring up today, was injunctive relief relative to the payment of monies to Mr. Powers, and then the relative prohibition on Champion funding any attorney's fees on behalf of Mr. Powers. They sought that in their papers. They didn't argue it today. If it's withdrawn, I'll move on. If it's not withdrawn, then
we'll clear that up. But your first of those next 2 is you're saying that the motion for contempt sought as one form of relief. Champion stop paying Mr. Powers.
Correct.
Whether it's the salary or the allowances.
Correct.
Okay. And okay. I didn't hear you say that either. You like to talk about it, Mr. Snyder, the fact that he's getting paid, because that is circumstantial proof that he is employed by someone for whom he's not supposed to be working. And then you have coupled it with what appears to be work done for Champion.
Sure. And my short answer is he shouldn't be getting paid. I'll put that as bullet point 7 on my asks for relief here.
Well, it'd be 8.
I'm not 8. I'm sorry.
Okay.
If Champion wants to continue paying him, I think that's crazy. I think that
I guess if I find it to be contemptuous, then Champion would be inviting ongoing contempt. And that may be what Mr. Capua wants to focus on, that it's not contemptuous, or it would be inappropriate for me to conclude that being paid by Champion equals working for Champion. So it's still on the table. What was the second?
And just only one other point is he's also getting some kind of allowance. So it's
Understood.
not just a salary.
No, but we'll talk about the whole package, but you had two others.
Then there's two other ones then. Then there's,
Oh, Mr. Powers ought to pay your fees and not Champion ultimately paying your fees.
they sought that relief as well,
Okay,
which again, there's no law that supports that. Champion can do whatever it wants under its contracts with third parties that aren't subject to the contract at issue in this case, which is a non-compete, non-solicitation agreement.
sure. What would my authority be to say that issue an order that says Champion can't pay Mr. Powers's legal fees? It might represent additional form of continuing employment. And then I could say you can do it, but I'd find that it's contemptuous because I've said he can't work for you. And if you're paying them, he's working for you. I don't know that I'd say that, because I think there are lots of executives who leave firms, have some liability for something over which they presided, and part of their departure is, I'm not here anymore, but you're paying Davis Polk Wardwell until I die, because I may be dragged back into court for the battery acid we let leak into the Hudson River. And that's just part of my package.
Right. And that's where I was going, Your Honor, is that it's a form of compensation, remuneration, something like that. I'll note that when I took Mr. Huff's deposition, I asked him, was there anything on the table here? Was there any plan for what happens if the judge gives me what I want and puts Mr. Powers out of work for compensation, anything like that? Mr. Huff said, no, we hadn't even discussed the possibility. So the idea that this is part of some agreement or compensation package or contingency plan doesn't hold a lot of water.
Okay.
Again.
All right. So those are both on the table still. Don't pay him anymore and don't cover his attorney's fees. So you should address those in whatever way you want.
Okay. And I'll get back to those in just a minute. The last thing they sought in their papers that they did not bring up today was this prior restraint on communication. They seek the court to expand the injunction to prohibit any contact between Mr. Powers and Champion, or Mr. Powers and customers of Champion, or Mr. Powers and potential customers of Champion. Court can't do that. The law is very clear that prior restraints are the most offensive type of legal order that infringes upon the First Amendment. And in fact, they're constitutionally, presumptively unconstitutional. There's no basis for them to do that. The court can't do it here. The underlying contract doesn't have this no contact with anybody under these circumstances type of provision that would give rise to their right to seek such prior restraint. So I'll just put that aside for a minute and then get back to kind of where we started, which was Mr. Schneider talking about the fact that Mr. Powers has been paid and continues to be paid by Champion from the beginning through today.
Okay.
That in and of itself is not a violation of the non-compete agreement, nor is it a violation of the preliminary injunction. The injunction prohibited Mr. Powers from working. It did not prohibit Champion from paying Mr. Powers anything. It did
Almost
not,
like a retainer. I mean, my thought was when I learned about this, I'm not sure the allowances piece, but it seems like it could be structured in any way. We don't want to lose you. The judge has said you can't work for us for a while. We get it if you went to work for company number 3, and then there'd be a new lawsuit, Williams versus whatever that is. Maybe not, but we want to keep you. You're valuable, and so we're going to throw something in your direction just to make it worth your while to effectively do nothing or forego the earnings potential of being at competitor number 2 of Williams's. Stay with us. Eventually, this year will run, and we can embrace you, and you can be at Oyster Creek and Pilgrim and Fairman.
that's exactly right.
Okay.
The purpose of the payment wasn't for services rendered. as what they're alleging. It's simply because Mr. Powers is unable to work at Champion per the court's order, and Champion wants to make sure Mr. Powers comes back when the injunction runs.
It sounds like rather than a wacko judge, it was a smart judge because he gets a year paid vacation courtesy of Champion.
Well, certainly weren't my words of wacko judge, but
I did not take it personally. I've been called far worse. It's always interesting to read people's supposedly unguarded communications, but it's a stick around payment. We don't want you going anywhere.
exactly. And Mr. Powers could, in theory, go to somewhere else. And then, like you surmised, I'm certain Williams would be a plaintiff in another case and we'd be fooling around again. So that's what the payment is for. It in and of itself is not violative of the agreement. It's not violative of the TRO, and it's not violative of the injunction. If Champion wants to make a business decision to pay Mr. Powers, they can. And that's what that payment is. It's nothing else, nothing more, nothing less. It's frankly that simple. So let's talk then a little bit about, and I think it's important for everybody to have some appreciation for the nuclear energy industry. We've all in this courtroom learned a little bit about these things during the 2 days of trial on the injunction and during these arguments from the lawyers. But one thing is very clear. This is an extremely safety-driven industry, which makes sense, Judge, because you're dealing with the moving and transporting of nuclear fuel and active operating nuclear power plants and doing specialty coatings in those active nuclear power plants. Williams, of course, doesn't fully comprehend that because they stopped doing that work years ago. As the court remembers, Mr. Lay testified they sold that equipment before he started in September of 2019. He said the work at Fermi wasn't competitive and specialty coatings is not part of their industry because that spreadsheet the court referenced earlier was a spreadsheet prepared or PowerPoint prepared by Williams executives where they said we are missing the capabilities to do that work. That was Mr. Lay who testified about that. It wasn't Mr. Anderson's PowerPoint. It was Mr. Lay's PowerPoint. They quit doing that work years ago. But that work is extremely safety driven because any fault could be a serious problem, as everybody recognizes.
Do you really think Williams doesn't appreciate the safety concerns that exist in doing work at nuclear power plants, whether it's pad to pond or decommissioning or special? I mean, I get it. I was a kid with 3 Mile Island. I don't think you need to be currently active in the field to appreciate that there are 1 billion regulations. It's very expensive, and a mistake could lead to a radiation leak and having to relocate hundreds of thousands of people. So it's not real compelling to say Williams doesn't understand.
They certainly understand the safety issue. Here's the context why that's important though, Judge, because when the court, if you look at the slides he has, it was slide number 12, Powers to Huff, March 3rd, 2022. That was one of their strikes. Mr. Powers says, I need to update Trice this morning. He is going to be pissed at Williams. He still calls me to keep me in the loop on any issues like the labor agreement negotiations. That is Mr. Powers simply saying, look, Trice needs to know about this. I mean, he did in fact testify during the proceedings. He's entitled to know. Mr. Powers updating Trice about the fact that the injunction came down the day before. That's not violative of the injunction. Mr. Powers is certainly authorized to tell Mr. Trice that he has been enjoying from working at Champion. That's all this text message says.
Okay, it is what it says. It also suggests that Powers, had an active and meaningful relationship with Trice leading up to the preliminary injunction. Otherwise, why would Trice care that Powers is going to be temporarily out of the loop?
Well,
and an active and meaningful relationship with Trice would be inconsistent with staying in the penalty box.
Not necessarily.
Okay,
and
walk me through that.
Sure. So here's the thing about Mr. Trice. We heard him testify. He's responsible for a multi-billion-dollar trust that decommissions these nuclear facilities. That's what his job is. Mr. Trice had a relationship with Mr. Powers going back decades. So we can't say that all of a sudden he needs to turn off all communication with Mr. Trice. The injunction didn't order that, nor could the injunction have ordered that. Mr. Powers is allowed to have communications with Mr. Trice. What he's not allowed to do is say, Mr. Trice, you need to go over here to Champion. He's not allowed to do that. He is allowed to have communications with him. And Mr. Trice zoomed into this court proceeding to testify about the relationship he had with Williams. And the reason he left Williams wasn't because of Powers, but was because of Williams mishandled a fatality, and Williams's reorganization, as they call it, has been a cluster of a disaster, as is shown by the people fleeing Williams's management going elsewhere. That's what Mr. Trice said. So of course he has a vested interest in knowing what happened at the proceedings because he testified at the proceedings. So that in and of itself cannot be contemptuous. He's allowed to communicate with people. And if Mr. Trice calls Mr. Powers to say, hey, by the way, this is what's happening, that's not violative either.
Why does Mr. Powers have to do that? It was pretty clear he needs to back off doing work for Champion. I mean, that probably the brightest, clearest line. So why wouldn't it be? I'm just sort of surprised, frankly, why Mr. Huff doesn't step up in some of these scenarios. Like, hey, here's the deal, Kelly, you're our guy. Here is $8,000 a month to go live on a beach, and we'll see you in not many more months. I'll handle this. I'll call Trice. I'll call this or that. You don't pick up the phone. Why would you do that right now? Why would you shift to WhatsApp? And we don't have everything, but I don't see a lot of that pushback of like, what? It's just, this is real simple. Go away.
And I think that's happened. I think the message is and has been, we're going to pay you. You better come back when your injunction runs. And we're looking forward to doing business then. That is what's happening.
Yeah, but then I send you an email on your AOL account regarding Rusty Gasser. Because I'm on the beach, I'm bored, and let me tell you about Gasser, and here's some information. This is going to benefit Champion, but I'm not working for you. I'm just getting paid $8,000 a month. So here's a solid I'm doing for you, and we're going to call it barter and not employment. No, $8,000 for this referral.
I don't think you can call it barter or employment. Mr. Gasser had already left Williams at the time.
As admitted by Williams, and he didn't have a non-compete. Exactly. So why is Mr. Powers reaching out to Mr. Huff through the secret channels? And why isn't Mr. Huff saying, hey, Kelly, stop. Don't send me a Christmas card. Send me an Easter card. We're not forgetting about you. We're $8,000 into it every month. Don't reach out to me. What do you not understand about the judge's direction? I know you're not Mr. Huff's lawyer, so I'm not asking you to defend Mr. Huff, but you're putting a gloss on things that I don't think things support.
But see, the issue is, though, again, it has to be in the context in which we're operating.
Which is, don't communicate with Huff about stuff that would benefit Champion.
Okay, let's isolate that, put that in the bucket. I'll let Mr. King talk about Mr. Huff.
But I'm talking about Powers.
I'm talking about Powers too. So Mr. Powers and Mr. Trice, they are allowed to communicate. So if Mr. Powers wants to call Mr. Trice and say, hey, the judge enjoined me, I can't do this anymore, he's allowed to do that. And so strike number, I think it was number 6 of theirs, isn't a strike. He's allowed to communicate with Mr. Trice. With respect to Mr. Gasser, if we were in a vacuum, and it's funny, Mr. Schneider said in law school this might matter, but in real life it doesn't. It's actually the opposite. In real life, it matters because we're dealing with, as you indicated, a potential risk that could affect millions of people. If Mr. Powers needs to notify Mr. Trice of a serious issue, he's allowed to do that. Same thing with the other strike, which is actually not a strike at all. Slide 15.
Before you move off that, what is the national security risk that not letting it's not Trice now, it's Huff, not letting Mr. Huff know about Rusty Gasser's personal email and his salary when he was at Williams? And let me give you a title for him. Let's call him VP of Operations at the company where I'm not working right now or the next few months. I'm just getting $8,000. How does safety in the nuclear industry play into Mr. Powers' questionable decision to engage with Mr. Huff on an app that supposedly makes the communications disappear in short order, and we're using the personal email account of Mr. Huff? I'm trying to burnish this in a way that looks good for Mr. Powers, and the silver polish is not working for him.
I think at most that incident would be a technical violation of the injunction. At most, it wasn't an intentional, I'm going to screw the judge's order over. It was, hey, Gasser reached out, here's some info, roll with it. But that doesn't, the injunction was on the non-compete anyways. This isn't competitive work regardless. So even if.
The injunction was don't work.
Correct.
Don't work, period.
But sending somebody a name isn't working.
Okay.
And so this goes back to, this was one of their strikes, which is slide 15, and it's powers to Huff, quote, the judge ruled I cannot work at Champion until the end of my non-compete. I'm completely shocked. Okay, that's fine.
Mm-hmm.
Next text. I am guessing I should not meet with Jim Carter and the contractor at the new office tomorrow. That's Mr. Powers saying, I can't be involved in this.
It is. It's also Mr. Powers saying, but for that pesky injunction, I was going to be meeting with Jim Carter and the contractor at the new office tomorrow. If you all are here to tell me that's an office dedicated solely to the Fermi project, everyone should be okay with that. But that's not the sense I got from it. That meeting with Jim Carter and the contractor that has been inconveniently canceled by that preliminary injunction probably didn't have anything to do with Fermi. And that's a problem because that's your client outside the penalty box. And the penalty box, not my idea, actually, Mr. King's idea, a great idea. I think that was a way to accommodate it the way they do with these doctors who can't compete here. So they go to Charlottesville and do hand surgery there, not in Atlanta. But they just weren't guardrails that Mr. Powers wanted to abide by.
But I'm not sure. Can I tell you this was only for Fermi? Probably not.
I bet Mr. Powers couldn't either.
Probably.
Okay.
But this text message in and of itself is still him saying, I can't be involved in this anymore. So to the extent it was a violation, again, it wasn't an intentional violation. He's attempting to absolve himself of those issues. So if you go back through and you get back to the relief they're seeking, I think under this context, it's important to look at it. So the maximum fine is $1,000 per violation. If their argument is, well, this is a continuing violation from day one of the injunction until today. There's no evidence of that. They haven't established a continuing and constant violation for every day to be a violation. So that doesn't work. I think at most what the court can do is you could do potentially a per diem based on those days in the text messages that we have. So if there's a text message on March 3rd, that could, in theory, at most be the violation.
If the text message was something other than, hey, by the way, I can't do work with you right now because of the injunction. And I get your point that there are some standalones that wouldn't qualify. And so I ought to be looking for the text that if I am more persuaded by plaintiff's presentation, I conclude we're inconsistent with the TRO and or the preliminary injunction.
Right.
Okay.
Right. With respect to the striking of pleadings, which is the relief they sought today during the hearing, they rely on the Dana Sharkey case, which is the 361 Georgia App 541. That's the same case that said you can't toll the injunction. You can't extend the injunction beyond their the scope. But they're trying to use that case to say, but you can strike an answer. That's not what that case said. What that case did is they reversed a court extending an injunction based on contempt. The parties there did not appeal or challenge on appeal the striking of answers and attorney's fees. And in fact, the court noted in a footnote, which it doesn't often do, that the defendants do not contend the trial court erred in finding in contempt, striking his answer, or awarding fees. And so we do not address those aspects of the trial court's order. But here's what's interesting. Then it cites a case that says, explaining that we will not address a potential issue if the appellant doesn't raise it. So that's usually a sign saying, next person come up here,
right,
raise it.
You may want to flag this next time.
That's right. So that case doesn't support their relief that you should strike an answer or enter any kind of pleading like that that would do any kind of striking or dispositive issues. Same thing with attorney's fees. Today, they say they're seeking it under 915-14, which is, of course, the statute that governs the conduct of the parties during the litigation. That's where if you file papers that don't have a basis or don't have a substantial basis, then you can seek fees. That's not what's happened here. They filed a motion, and they're not saying that the lawyers have filed anything violative of 915-14. They say the parties, Mr. Powers, breached your injunction. That's not 915-14. That's contempt. So they can't get fees either. That's not part of their entitlement to under the law.
Well, I mean, I'll look at that. I find it attractive, the attorney's fees form of relief, as opposed to some of these others, insofar as, and I analogize it to discovery disputes. And in the end, I decide that it was a frivolous objection and someone withheld something, but someone had to file, it's sort of a motion for contempt. We tried a 6.4 and they're just not disclosing X. And sometimes judges can say, all right, not only do you have to disclose it, but it costs them $800 to bring this motion. So disclose it and slide a check across for $800.
And that's true. That happens all the time in discovery disputes. I think the reason is the rule 37 or 91137 expressly authorizes that as a remedy for contempt. In fact, I think that rule says the prevailing party shall be awarded their fees, although shalls often may, as the courts often are. So I think the analogy is good. I don't think it's directly on point.
Okay.
And if they're moving under 915-14, they have to establish the 915-14 bases, and they haven't. I don't think they've even tried, really. There's really no affidavits of fees or anything like that that would be out there. I think, Judge, I know we're running out of time, so I think
it's all right. I got to give Mr. King time too. He's going to learn someday not to go last, because I was like, Mr. King, you've got 30 seconds. What do you want to say? It's like, Judge, 30 seconds. But
I'll pass to Mr. King to give him talk.
Judge, this is Kelly Powers. Can I say one thing?
Well, why don't you text your lawyer first and share with him what you want to, he's going to look at his phone. He's been very focused on making his presentation. So let him look at his text. I'll come back to that, Mr. Powers. I am not saying no. I want your lawyer to say yes.
Thank you.
And I am going to ask your lawyer one more question, and after he has a chance to look at the text, and then I'll hear from Mr. King. Anything you want to say about the Braves tickets?
Sitting here today, no, except that it's not violative of the injunction. We're here on contempt. We're prepared to talk about contempt. We're not prepared to talk about
sexy, but it's not from your eyes. It's not contemptuous of an order.
It's not.
Okay. All right. Do you want a chance to communicate with your client? And I'll pivot to Mr. King.
I would.
All right. So, Mr. Powers, we will come back to your request. I'm going to hear from counsel for Champion. Patient counsel for Champion. Who likes the podium?
Well, I also don't have a.
Oh, you don't have a mic? That's right. You're at the.
I was paying attention to the court's
Yeah, the
instruction.
second. No, I appreciate it, because the court reporter very quickly would say, this guy, I can't hear him.
Your Honor, Michael King with Greenberg Treurig on behalf of Champion. I don't have a lot to say. I will say that Mr. Huff and I and Champion regret that he sent or participated in the text discussion in mid-March. It was not intended to be a violation of the court's order. But if you look at the specifics of the court's order, which prevents Mr. Powers from consulting with Champion, that's what happened. Shouldn't have happened. Regret that it did happen. It wasn't intended to be a violation of the order, but it did. That being said, that is one instance in which Champion and Mr. Huff participated in a communication with Mr. Powers that was inconsistent with the court's order. One strike.
not 120 day strikes, not 8 strikes, 1 strike.
You understand the concern, though, that if there's one, maybe there are more, and there do appear to have been steps taken by Mr. Powers. He's initiating these, using these different forms of communication that are more obscure or less easy to track down. Or if the discovery request is, please have Mr. Huff provide any relevant emails from his work account. Well, gosh, his AOL account's not his work account. So if you, as Champion's lawyer, direct the Champion employees to scour their Champion email accounts, nothing on the AOL account will pop up. So there are some optics that could cause one to say, well, how do we know this is the only one? And that gets more towards the forward-looking relief, not fines, not incarceration, but we need to get another snapshot of, at a minimum, Mr. Powers's communication, so we can see if he's using some NSC method of communicating with Mr. Huff now.
Sure. So this takes us back to a question you had for us before we were on the record, which is, where are we on discovery? And the parties all represented to you that we are in discovery, we are actively in discovery, and that there are no current problems to raise with you about discovery.
There's some 6.4s, but right now they're at a slow boil, not a rapid boil.
So you have to take the parties, at their word when they say that they are actively producing documents. We have an obligation, as you've said, to produce documents. That's different from coming in and saying, we have found an anomaly in the document production that requires a more severe sanction, namely, you need to image computers, you need to address who pays for what. We're not there yet. Now, I'm not saying that there aren't going to be a question or two that might come up, but what we have on this record is not to speculate that there's other stuff out there that after March 21 that violates your order. So again, with apologies to the court about the instance that I've already described, we're not in violation of the order on a continuous basis. I can tell you, as I told Mr. Schneider shortly after the order came down, Champion immediately removed Mr. Powers' access to Champion's emails, its computer system. He has no access to that. The company was directed not to employ Mr. Powers. The individuals were in the company were aware, that needed to know, were aware. So we have been very forthcoming.
Not sure what that was. Back to you.
We've been very attentive.
Sorry, that was Johnny, my computer.
That's right. I just turned that off. That was Ms. Barnes's phone, but
Okay.
she's muted now.
We've been very
Your colleague, so the record's clear, not someone else's.
We've been very attentive to our obligations. And I think to explain, when we say Mr. Powers is not to work for us, Mr. Powers is not negotiating contracts. He's not supervising jobs. He's not visiting job sites. He's not doing the things that you would have associated with what Mr. Powers was employed to do. He is not doing those things. There have been, as had been described, some communications that appear to be of a consulting nature. But again, he is not violating the order in the standard form of being employed. He is not being employed. He is receiving essentially what you describe as a retainer, consistent with any kind of severance where, and his employment was terminated. He's being paid after the fact because he didn't have a job, and frankly, we didn't want him to get a job. So
Any particular reason it is characterized as salary and allowances, or is that just a mirror image of what his salary structure would look like if and when he returns in November? The numbers may be a little different, but it's about 5,000 in salary each month, and then there is this allowances piece.
it's actually weekly, Judge. I mean, you've said that a couple times. It's actually
It's weekly.
Yeah, I mean,
$3,000 a week for allowance?
$3,000 a month for allowances
Oh.
and about $4,700 a
A
week
week.
as compensation.
Okay.
I just want to be
No,
clear.
thank you. So it's an even bigger number, but
Yeah.
regardless of the size, it could be $1 billion a month or a week. It is sort of a mirror image of what the pay package was like pre-termination and more or less what it would look like post-termination.
Yes, Your Honor.
Around $5,000 a week.
Yep.
And then $3,000 a month allowances to cover your travel, your car, whatever it might be.
That's correct.
Okay.
All right. And then I want to just focus briefly on what the motion is. The motion is for contempt. The motion is not for attorney's fees under 915-14. That's a totally different procedure. It's a different hearing. You ask different questions in a 915-14 hearing than you would on contempt. The law is that you can't award attorney's fees as a contempt. And that's Rappaport versus Buckhead, 234 Appeals 363.
Give me just the numbers again.
234 Appeals 363.
Thank you.
And if we were here, if we had been given notice of a 915-14, we would come to talk about something else. I came to talk about attorney's fees not being recoverable in a contempt. But again, there's a whole different record under 915-14 that needs to be made, and it needs to be by motion, and it can't be just raised as a throwaway tagline at the end of an argument. So you don't get attorney's fees under these circumstances. Similarly, the stricken answer would be a sanction for some type of abuse of the process, which we don't have at this stage for you to consider. So with that, Your Honor, and again, with apologies, we ask that the relief be limited as to Huff and as to Champion to the one strike that we identified in that March 2022 communication, and that the relief go no further.
Why should the communications between Mr. Powers and Mr. Carter that seem to be inconsistent with staying in the penalty box not be counted against Champion? Certainly not Mr. Huff.
Right.
But again, he's not a named defendant here. I get why he has been looped into this contempt pleading, but why not the Carter Powers exchanges? I think this was back when text was safe in Mr. Powers's mind.
Yeah, well, the answer to that is that Champion has, and there's no evidence of this to the contrary, Champion didn't have knowledge of these communications. They don't appear on Champion's emails. And so to the extent that there was a communication, it wasn't sanctioned by the company and it wasn't conducted with the company's knowledge.
It may be Mr. Powers's problem. It's not your client's problem.
I don't want to say it in that
I'm saying it though,
fashion.
but I mean, that's what it sounds like. You aren't saying those communications were okay. You're saying, Judge, if you find that those communications were not okay, i.e. violative of the TRO, they weren't Champion communications. They were text messages between, yes, a Champion employee, but there's nothing in it that says, I checked with the CEO or I checked with Mr. Huff. It's Carter and Powers doing what they do and what they do may be contemptuous, but that's not a champion issue.
Again, I don't want to
You
put
don't
it in
want to
that
agree.
position, but it is true that the communications weren't sanctioned. And as I understand it, in retrospect, I understand that there is a longstanding personal relate and friendship between those two gentlemen. Thank you, Your Honor.
You're welcome. Mr. Kapler, you can add anything you want as sort of this unofficial joint defense. Include in it, please, anything in connection with Mr. Powers's request to be heard. And then I'll give Mr. Schneider the last word.
Yes, thank you. So I did have some correspondence on my phone with Mr. Powers during Mr. King's presentation, so I appreciate you coming back. To first address the office issue that was raised where Mr. Powers says, hey, I can't meet with the contractor to talk about the office. That was intended to be the office where Mr. Powers was going to work. And so, of course, Fermi is in Michigan. Mr. Powers lives here. He has to work from somewhere. It wasn't in further of taking Holtec's business or anything like that. That's not what that was. It was, we're going to build an office in Georgia for you to work at. And because you're going to be working there, you can have some involvement in the building. That's essentially what that was. That's not going to be violative of the injunction either, or of the TRO.
Hence the new office. I mean, that the word new is in there.
Right, exactly. So
Okay.
if he's working out of his basement on day 1 and he's moving to an office on day 5, that doesn't mean there's been a violation of the TRO.
Okay.
So that explains those messages. And it shows that Mr. Powers was saying, maybe I shouldn't even be involved in that because I'm not allowed to work for Champion at all in that March 2nd text. So I think that explains those communications with Mr. Huff about the office. Mr. Carter has been somewhat of a figure here during today's proceedings. And there are some text messages relative to what's happening between Mr. Powers and Mr. Carter. What Mr. King said is exactly right, that Mr. Powers and Mr. Carter are longtime friends. And they've known each other for a long time. Mr. Carter used to work at Williams years ago. He was laid off during a prior restructuring that Williams seems to do every couple of years. They have obviously stayed friends, and they're still friends today. So what those messages do, again, Mr. Powers wasn't thinking that this was going to be a violation of the order. If he gets a call from Mr. Trice or whomever, again, Mr. Trice is allowed to call Mr. Powers or anybody else. He's simply passing on the information that looks like something may be happening to Mr. Carter so that he could take appropriate action as appropriate. Again, the reason being that this industry is obviously has a severe public interest in the right people doing the right work, doing the right jobs. And so if Mr. Powers receives information that is important or critical to the safety of a nuclear power plant, he's going to pass that along to somebody in the industry. And that's what he was doing with these text messages. It wasn't intended to compete or to violate the injunction. It was simply intended to say, hey, I heard this. Y'all should be aware of it.
Got it.
So I'll echo what I said earlier, what Mr. King said. Attorney's fees, this isn't the proper vehicle for that. Incarceration is not the proper vehicle. Forensic review of other people. I still have Mr. Powers' iPad. So nothing has changed on it. I've had it now for months.
Right, but that's old news. I mean, what I heard Mr. Schneider saying is we may need to see what's on the new iPad, not what was said historically, but if, I'm making this up, but if Mr. Powers just yesterday was like, hey, Kelly Trice, whatever Mr. Trice's first name is.
It was Kelly.
All right. Hey, Kelly, it's Kelly. What's going on at Oyster Creek? I need to stay in the loop for when I get back to Champion. Maybe that's relevant to what's going on. Maybe it's not.
But see, if that's all he's doing, that's not violative either.
Well, that's a bad example. Let's say it was a good example of violative conduct.
Sure.
Kelly Trice, it's Kelly Powers. We will be bidding on this with Holtec. And I'm sharing this with you as one of Champion's former and soon to be senior executives. Problematic communication. That's not on the old iPad. That's on the new iPad.
They can certainly send an RPD to us to do the same thing again.
Okay.
We've done it now 2 or 3 times. We can do it again. It's not a big deal. And we will do it again. And the protocol we've now established with their people where they image it and there's approval for us to look at things before they're produced, that has worked. And so if they want to serve another RPD to do it again, we'll do it again.
Okay. So two quick last questions. One,
Yes, sir.
you have covered what Mr. Powers wanted to share. He wanted to explain, hey, this new office is actually, it's my office, Mr. Powers in Georgia, because I let everyone know I'm not going to be in Michigan all the time supervising that project.
Of course, he has to work somewhere.
Okay. Second question. You kind of tried to slide incarceration into the same category as attorney's fees. Your argument for attorney's fees is they are not legally allowable for contempt. Incarceration is legally allowable under criminal contempt. Is your point it doesn't fit the nature of this violation, or did I miss you pointing out, no, Judge, it actually would be legal error for you to decide that Mr. Powers ought to go to jail for 8 years or 120 days or 10 minutes?
I think it's both. Number one, these types of issues where it's not an intentional, we're going to compete anyways. It's, hey, I can't be involved in an office, or, hey, I got this information from Solar.
Well, but that's your spin. If my view is that your client knowingly and willfully and intentionally violated a pretty clear order, then I believe that incarceration is an option I have. I'll have to do some reading, but you two, King and Kapler, are saying attorney's fees are not an option. It's just not on the table for you. And I will respect my limitations, but you lumped incarceration in with attorney's fees. And I wanted to know if, like, yes, if you read this case or this statute, you actually couldn't, it would be legal error to incarcerate someone.
I see what you're saying. The answer to that is they didn't move forward. They sought the maximum fine in their papers.
Okay.
And so in terms
And
of
the very first thing you said is that jail is off because their motion, their papers, asked for A, B, C, D, E, F, and G, none of which was incarceration, and they can't switch it up now. You didn't prepare for that. And really, you need to ask for what you want in your pleading. That's how people know what to respond to, and that's not what they asked for.
that's right.
Okay, thank you. Mr. Schneider,
Okay.
final words.
I will try to be brief.
Just say what you need to say. I'll cut you off if I have to go.
Okay. Thank you, Your Honor.
Don't say too much.
Why isn't Mr. Powers here testifying about this office? Why isn't Mr. Powers testifying about any of these emails, or I'm sorry, any of these text messages?
So I'm not going to make him put on the record. My understanding is there's a family emergency. You're going to believe it or not believe it, but I'm going to good faith accept Mr. Powers is not here. Well, I guess we should be clear. He's physically not here because of something important going on in his life that doesn't relate to competing or not competing with your client.
Sure.
If your question is, why hasn't he popped up on the screen, taken the oath and done these things? Point well taken.
Or an affidavit. I don't see an affidavit. I don't see him popping up on the screen. He's obviously here.
Virtually.
And if I was crossing examining him, I might ask him. So Jim Carter, the former Williams employee who now manages Holtec work for Champion, that was the guy at Champion that's building your new office? Okay. Why, after everything the court has heard and everything we've seen in this case, these guys would get the benefit of the doubt on any of it, as to what any of these texts mean, or any of these WhatsApp messages mean, or that it was unintentional? Why are they on WhatsApp? They know what they're doing is wrong. Why are we sending emails to somebody's AOL account? These guys know exactly what is going on. As far as Champion not knowing what's going on, Huff knows. And you want to tell me these other guys don't know? Okay, but Huff knows, and this is a company with hundreds of employees. Huff's on the executive team. He reports directly to the CEO. He's sitting in the CEO.
Hasn't been confirmed.
Sure. He may have been sitting in the CEO's office. Okay. I'm not buying that Champion doesn't know what's going on here. That's me. And one strike equals 20 days in jail. All you need to find is one strike here. And that's 20 days. And there's multiple strikes.
So pause, please.
Sure.
Mr. Kapler says jail's not an option for me to consider because you didn't ask for it. You've, I guess, arguably verbally amended your pleading, which I guess you're free to do. I would then need to give the defendants a chance to respond to that. Maybe we have to have another hearing so that they can get on the record what they want to get on the record. Although I don't know that the record would change all that much unless they find some texts and WhatsApp messages that are different from what you had. It just would be more of a, what's reasonable in this setting? Is jail a reasonable sanction for this allegedly or arguably contemptuous or contumacious behavior?
One, I agree with you. I don't see where anything changes because we're still trying to prove the same thing, contempt. They're trying to show that it was unintentional. So nothing changes from an evidentiary standpoint there. Two, we don't need to ask. The court can do it on its own. It's among the statutory penalties that the court can issue. It doesn't have to be at our request. It doesn't have to be by motion. Third, we asked for it. Mr. King brought it up in the preliminary injunction hearing. I quoted him in the second paragraph of the brief, raising it. We asked the court for all relief that the court may deem just and proper. And the court has the ability to fashion all allowable relief. And that's what Williams asked this court to do.
Right.
To suggest they weren't aware of imprisonment as a possibility here, that's just, it's disingenuous. As far as the communications with Trice and with Carter, because they're old friends, I can't for the life of me understand why they're fighting for that right to do that so hard. Well, I do understand. I'll take that.
Well, but set aside the old friend. I don't find that particularly persuasive. They're old friends, but they also happen to occupy a position that makes it complicated for Mr. Powers to speak with them about certain things. Mm-hmm. I do find persuasive this notion that Mr. Powers can reach out to Mr. Trice any day of the week to say, hey, man, did you watch that golf tournament? What do you think about LIV versus the PGA? Arguably, he's cultivating a relationship, First Amendment right to talk to his friend of 30 years. They play golf together 100 times, albeit through work conferences and whatnot. And there are limits to what I would say you can and can't do with these folks. And it gets gray, and some of it may get in the gray area, but are you saying that it just needed to be no contact at all?
No, but that's not what I'm seeing here.
Okay. Well, to be clear, I'm not saying the only contact was, we'll call it clean contact. But if there was, if what you had, well, let's take the one example. Powers reaching out to Huff on, this is the March 2. So we've shifted to WhatsApp.
Okay.
And Mr. Powers says to Mr. Huff, I'll probably let Trice know what happened tomorrow. As in, Mr. Trice, I'm going to reach out to you on the 3rd to say this crazy judge has said I can't work for Champion anymore. So don't reach out to me. Don't think it means I don't care anymore. I love you. I love Holtec. I'll be back in 5 months.
And yes, Your Honor, and you didn't hear me argue that call to Trice was a violation of the PI, because that's actually a reasonable thing that somebody might do.
Okay, then
That's not what I'm talking about.
Okay, I just wanted to make sure you weren't trying to draw a line that any contact with a Trice or a Huff would be problematic. It needs to be topical.
To the extent we ask for that as additional relief, it's because of everything we saw here today. It's not to stop them from talking about the Patriots or the Falcons or whoever.
Okay, the 49ers.
Sure. And I'll just say on the attorney's fees issue, Stardust case, there's all sorts of cases that say you can award attorney's fees on a contempt motion. 915-14 specifically says, upon motion of any party or the court itself, if it finds that an attorney or party brought or defended an action or any part thereof that lacked substantial justification, or that the action or any part thereof was interposed for delay or harassment, or it finds that an attorney or party unnecessarily expanded the proceeding by other improper conduct.
Now, I know what 915-14 is, and sadly I have to deal with it more often than I'd like. It typically comes up at the end of all the proceedings. Doesn't have to. Something could come up partway through, a messy discovery dispute. But I have always seen a specific discrete 915-14 motion separate and distinct from contempt. So I mean, one answer may be you're going to file in 2 days a 915-14. I don't mean to make work. And frankly, that might just cost the loser of that motion, if it doesn't go well for Champion and or Huff, even more money. But I don't see the direct avenue from contempt being 915-14. I think they are two different things. They can overlap. It could be the way you are unnecessarily expanding the proceedings is by making us have this contempt hearing because the texts speak for themselves, or the Braves tickets speak for themselves, or whatever it is that I end up finding, if I find anything was contemptuous. But it strikes me as being a parallel, linked, but separate chain of pleadings. That doesn't mean, I'm going to go read Stardust, that what a judge can do as a result of a finding of contempt, say, and another thing, you're going to pay the attorney's fees. I just would be surprised if what the case law says is, oh, and your hook, judge, is 915-14, because I mean, there's all sorts of case law about filing it, when you have to file it, when you have to give a hearing about 915-14, and then the different standards of whether you must, shall mean shall there, or you may. And that's why it's typically I'll call it a separate proceeding. It could happen at the same time, but there would be two different strands of pleadings, contempt and the 915-14. So I don't know the answer. I'm just saying, insofar as you want to travel under 915-14, unless there's case law out there that says that grows organically from contempt, then it may be that you're one pleading shy of being eligible for attorney's fees.
Well, I'll start with that last point. I'm happy to file a separate motion if that's for the court.
I'm not directing anything. I'm going to look at it, and I won't leave you in the dark. I will make plain to both sides. I can and will require attorney's fees to be paid if I find someone's in contempt, or it is a well-placed request. I'm favorably disposed to it, but I don't believe I'm authorized to provide attorney's fees as relief for contempt if I find contempt. And then you'll have a chance. I don't think you waive anything. It just means you'll travel a little bit later.
Understood.
Okay. Anything else? Nope.
That's all, Your Honor.
Mr. Powers, I hope that whatever's going on with your family is something that you and your family are able to manage, and that whatever it is clears up soon. Mr. Kapler, Mr. King, thank you for your time. It's good seeing you both. Silent partner to Mr. Kapler, thanks for being here, providing support. I will take this under advisement, and if I have questions or need anything else, Ms. Niles will get an email out to all of you. You know the routine. If I decide that it's kind of complicated, but one side pretty clearly prevails and we would get an order out sooner, I may pass the pen to that side. And that is authorship of a draft only. And that draft, then everyone could see, not to change the outcome, but to say, hey, change this language a little bit. Because again, Champion isn't Mr. Carter. You mean, you may want some prophylactic language in an order that gets us to the destination I think is the right destination, but does it more eloquently, if that's where we're heading. Mr. Schneider, last thing, do your best to work things out at the 6.4 level. If you don't, my standing order makes clear, do not file a motion for contempt for discovery issues. You reach out to Ms. Niles and say, we are at loggerheads on this issue. And then we'll start by trying to do a phone call, save everyone a little bit of money to see if over the phone, Zoom, whatever format you want, but virtually, can we navigate that discovery dispute? If you file the motion for I'm not getting what I want, it'll have been filed. Don't think you'll get reimbursed for it if you win, because I don't ask you to file things like that. You simply tee it up with an email. We tried with 6.4, good faith effort was made, couldn't sort it out. And as long as you kind of outline what the issue is so that when I get on the phone with you all, I know what the beef is, we'll work through it that way. All right, Mr. Snyder, anything else procedurally?
No, Your Honor.
I guess you've got a motion to dismiss to respond to. Mr. Kapler, anything else procedurally?
Nothing, Judge.
You've got a spoliation motion to respond to.
We do.
Busy times. Mr. King, anything else? Are you on the hook for spoliation as well, or is that powers only?
Powers only, but we will have a very brief response because some of the relief is against us, regardless of the fact that we're not charged with spoliation.
All right. Well, I look forward to all that. And again, if anything that you all make ripe by having motion and then response is burning a particular hole in your pocket, reach out to Ms. Niles, because I promise you, we don't check this docket unless we have to. And so I'm happy to make it a priority insofar as we can, but it is prioritized because you've reached out. Hence that whole, we can't agree on discovery. This method gets it to me quicker. Again, motions to compel or you haven't complied that sit for months, and then the case is stuck because you can't get that piece of discovery. But if the requirement is reach out to Ms. Niles, we always get people on the phone within a few days. So that's it.
It's worth having a chance to look at that Rico statement.
That's part of your motion to dismiss.
It's attached.
Yeah. Okay. Before everyone runs away, Ms. Bradley needs to be taken care of. I think plaintiff arranged it, but I need to make sure, is the defense joining in?
Yeah, Judge, we'll share.
Okay. All right. So Ms. Bradley knows how to get paid.
Yes,
Yes.
I imagine she does.
Okay. Well,
Get her
Ms.
paid.
Bradley, are you all set, or do you need me to get anyone on the record saying, like, here's my personal bank account number?
No. I do just want to make sure, Mr. Kapler, can you spell your name for me, please?
Yes,
Your last name.
it is Kapppler.
And then who is your supporting counsel? Last name again?
Jeff Reynolds.
I like that title, supporting counsel.
Supporting.
All right. Is that all you need?
Yes, thank you.
All right. Well, thank you, everyone. I'm going to end